Well, hello, everybody. Bob will be with us shortly, but we are here for the hearing that may tell us absolutely nothing. But let's uh let's get to it. Hello, everybody. I do hear Bob just came in. So we are going to watch the Karen Reed hearing today. This is in the wrongful death case. It is July 1st, Wednesday. Um, so I was really worried that we were going to have to um, do this on the webinar. So I was kind of freaking out because, like, I got on the Zoom and, like, I should have realized right away because the screen was says, like, you cannot live stream this, but I was too concerned with, like, was my video on or was it off or what the hell was going on? Was my audio on or was it off? Because when I tried to do it from the computer, like the browser, it didn't have like all the stuff that mine usually has, like when I'm in the app. So I'm like, where's like the button for me to make sure my camera's off and make sure my, my audio is off. I was like freaking out. And I think I was on there for a hot minute. I'm not sure. But then Tracy, so just as I'm like realizing, oh shit, this says you can't live stream it anyway. Tracy sent me the link for the people who are live streaming. It said, I think the message was, let's see, because I sent it to them. There will be no capital live streaming of this hearing. Only Supreme Judicial Court Rule 119 registered media can record. So I had it open for a while because I was like, all right, I'm just gonna listen and make sure they're not saying anything that we're not seeing. But um then I was back to not being sure if my audio was on. Like I went in and like changed my settings so it's like automatically off, but I don't know. I don't know. So we're just going to do this and hopefully this will work perfectly fine. So, hello to all of you and hello to Rosie's Overruled, member for 14 months. Well, thank you for your continued support. Love all you guys. Family hugs. I hear Bob up there just torturing me by not coming on. I'm just seeing what else you guys are saying out there. You're all just saying hi in your sweet selves. So let me just stick this up so we know we're watching it. And but can I not make it big yet because it hasn't started? Maybe that's what it is. No, that's all Bob's stuff. He loves his bears. Let me see if what it looks like on Law and Crime. Yeah, same thing. Like you can't. I think they're all just this one's better to look at on the screen here. They're all just have the same time. They're probably sharing the same screen, maybe like the same video. So 7 minutes. I don't know. So they all filed what I can tell you, okay, is that everybody, well, I don't know about everybody actually. And I'm going to check right now because when I checked last, it wasn't all the lawyers. And I don't know if that was just the clerk being lackadaisical or something else. So let's see if anybody else has filed their certifications, but all their certifications say, I have no information. I did not, and I have no information about anyone who disseminated any part of any content anywhere. So as of this morning, we got, let's see, Oh no, well, they came through last night. So it's the same 4 that were on here before. Certificate of plaintiffs and counsel regarding the order relative to impoundment. Might as well just share this. Okay. So this is by Bibliane on behalf of all of the plaintiffs, I guess. So I assert the following to be true and accurate under pains and penalties of perjury. I am an attorney admitted to practice in the state of California. My motion for PROHOC was admitted. I have not disseminated, nor am I aware of any facts regarding the dissemination of the contents of the material impounded pursuant to this court's order of June 8th, 2026, to any person or entity other than the parties and their counsel in this matter. So, and this is specific to this specific lawyer. And then, but although it was called certification of plaintiffs and counsel, I don't know how that's why it's titled like that, because it's really the certification of one lawyer. And maybe that's what they did, because there's one lawyer for plaintiffs, there's one lawyer for CNC McCarthy's, there's one lawyer for the waterfall, and then there's one for Karen Reed. So let's see who signed for Karen Reed. That's it. Aaron Rosenberg. I certify that I'm not aware of any facts to any dissemination to anyone other than the parties or counsel in this matter. Oh my gosh. Tracy just texted me. I don't know what's going on. I don't know what's going on. Annoying as shit. So it's not on the screen. None of it's been on the screen. Sorry, guys. Thanks, Tracy. So Aaron Rosenberg says certifies the same thing. So, and like I said, there's just one. What's on the record is one for each party. I think the other one that I was reading was this one. This is a lawyer for the plaintiffs. And that's it. They all said the same thing. So who knows? This may be a whole lot of nothing. A whole lot of nothing. All right. Coming back. I have no idea what's going on with my StreamYard. So I'll tell you how it works. Like I hit the share screen and then I click what I want to share and it takes me to that screen. And it's always automatically populated it onto the screen. So now that it's, for whatever reason, I do not know why it's doing this, that it started doing this. Yeah, that's it. I don't know. Well, thank you, LW9338. Appreciate that. We're going to put this back up. So but you guys probably can't see it. So I'm coming back. Unbelievable.
What'd I miss?
Nothing. Except it's still not sharing my screen. So
what do you mean?
Like I have to come back in.
Once again, all cell phones.
That is weird.
Off, not silent, off. Stow it away. Thank you.
All laptops turned off.
No secret recordings.
Secret recordings.
I don't know. Can we see who's over there? I see Alan Jackson. There he is.
AJ.
Came all the way from California.
Long trip.
Didn't file his certification though.
He did.
Yes, you sent them.
No.
Yeah, he did.
I just reviewed the docket.
I saw one this morning.
It's from Karen Reed, but it's signed by Aaron Rosenberg.
No, I saw one for Aaron. I saw one for Alan. I saw one from Karen.
What?
Yeah. I think Dee Dee had posted it on X with the links to all the certifications.
I see 4.
I saw more.
Well,
I'll check. I'm pretty sure it was Dee Dee's post.
No, I understand that. I still have to do it. Until the 2 lawyers get on, I can't start the hearing.
until the other lawyers get on Zoom.
Oh, thanks, IW. Appreciate you.
Yes, we do. Thank you.
Oh, babe, I was taking some heat and chat from Replay Crew with my constant interrupting of you last night and you having to shut me down. It was glorious.
You were just being a goofball.
I was totally, but I was playing the full role reversal, whereas I usually am the tech wizard and you're usually the one interrupting me. I flipped the script.
Oh
yeah.
Oh yeah.
That's my story, and I'm sticking to it.
Sounds like it. I can smell the Proctor right here. Smells like Proctor shit his pants.
Oh boy.
That's the bullshit coming out of you.
Oh boy.
Were you really catching not real shit, just fun shit? Right?
There's always the folks that I think are new to the channel, and they're like, yeah, it was a little cringy the way they argue. I'm like, you don't understand our shit.
I mean,
you're new to the game, clearly.
It was a lot yesterday, though.
What? I thought it was great.
But for people who are just like, what is happening?
I mean, I thought it was a great introduction to the hilarity and frivolity that we have going on.
Frivolity. Well, sir.
Yeah. It's good times.
Yeah.
It's good times.
Well, Christine says, I hope there's proof that Proctor is being harassed by phone and that they're not taking his word for it and merely assuming there's a leak. I mean, I would hope that if he comes at the lawyers, they're going to come back with, Your Honor,
what you got?
No, right.
Right.
You got.
Definitely. I mean, I think they have to. It's like, it's kind of the same concept of negotiating against yourself. Yep. You know what I mean? It's like, well, what is somebody saying happened, or what did you hear? You know what I mean? It's like,
thanks, Law ZC. Now for my second live of the day after my 5 a.m. start.
Woo!
5 a.m. start when Bob was on fire.
I mean, in retrospect, I think there was some probably pent up angst from losing in the All-Stars. I was definitely on fire, though. Yeah, my rant.
Hey, let's hear what they're saying.
Sorry.
I don't think he said anything.
Sometimes I'm going to be on one. That's how shit goes over here. Sometimes we are not for the faint of heart. Allie is a saint. Yes, she is. She is indeed a saint. Oh, you didn't put up my Venmo grift.
Yeah, I did. It's just that there must be a comment up or something.
You did? I don't see it.
Was that an Alan Jackson sigh? Or was like a loud one? Listen. Wait,
is it like that?
Wait. Maybe not. Maybe I missed it already. Wait. I guess I keep missing it. Oh, well.
Oh, yeah. There you go. Thank you. Oh, look at D Nice coming through. 5 DD podcast memberships. I love that. Thank you so much. Really, really appreciate that. And I know that the people that get the free memberships appreciate it as well. So if you were a beneficiary, please give D Nice some love. Thank you, thank you, thank you.
They're all sitting there dead quiet. Wait.
Paige, I think that yes, that is fair. I think that is absolutely fair.
Council?
But
Wait.
Hold on 1 second. Is it the
Any luck, council?
861 meeting ID? Yes,
okay,
sir.
it's some guy trying to get on Zoom.
No, I think they're still waiting for the lawyers who are supposed to be on Zoom.
Isn't that what I just saw? Okay.
Oh, no, I thought you meant like just some. I don't know.
Well, I think he
The
was
lawyers they're waiting for, right?
Yeah. I think that's okay to still think it's cringy, but I'm just gonna tell you, it's what a healthy marriage looks like.
I mean, I don't really think there was any like actual
There was
arguing, right?
it
You
was
were
fucking hilarious. Like when you shut me down, like at the one point where you're like, dude, like when you were trying to scroll through the docket and you were like, just dude, you need to shut the fuck up. I thought it was hilarious, but in my opinion, for a healthy, if you have to walk around your spouse on eggshells and mind your P's and Q's, it's not going to last. I'm sorry, it's just not going to.
I wouldn't want my man minding any P's and Q's.
I don't want my woman minding any P's and Q's. And when I need to shut the fuck up, I need my woman to tell me, yo, it's time to shut the fuck up. I rely on that. We are a partner. We're partners in all
I
ways.
see what happened. Tracy told me I had to keep scrolling.
What do you mean?
They should be popping up.
There was on the, I'll share this real quick and then I'll go back. So as you keep scrolling down, there's all the other lawyers.
Yes.
Okay. All right. We're going to go back to the stream that nothing's happening on. Don't worry.
Yeah. People get panicked.
Yeah.
While we're waiting, Claire, welcome back. Welcome back. I know you've been a member. You've long time in. So, family hug. We appreciate you so very much. Spoogs says, I know Bob and Allie don't do the drama, but have you two seen the clips of Jolene Lunzer's stuff? She's hilarious. I've seen some of it.
Wait, who's Jolene Lunzer?
She's a comedian who has taken upon herself to start a war with Jess Macchiato, I believe she calls her. Allison keeps asking me, she's like, who the fuck is Jess Macchiato? I'm like, I don't know. This woman who claims she was a whatever. We'll talk about it later. Yes, I've seen some.
All right,
for the record, civil action 2483 CB 0695. For the record, civil action 2483 CB 0692. This is Paul O'Keefe, individually and as personal representative of the estate of John Joseph O'Keefe III, et al. Versus CNC Hospitality LLC, doing business as CF McCarthy's et al. Your Honor, with your permission, at this time, I will call the names of the attorneys in attendance and ask that they state that they are present for the purposes of the record.
I want to know too, Life with Kylie.
We all do.
Hunte. Attorney Horwitz.
Present.
Attorney Fell.
Present.
Attorney Buck.
Present.
Attorney Diller.
Present.
Attorney Beaton has been excused, Your Honor. Attorney Holstag.
Present.
Attorney Rose.
Present, Your Honor.
Attorney St. George.
Present, Your Honor.
Attorney Donovan.
Present, Your Honor.
Attorney Deely.
Present.
Attorney McCaffrey.
Present, Your Honor.
Attorney Hassett.
Present, Your Honor.
Attorney Maravellis.
Present, Your Honor.
Babe, move the
Chief has been
captions up a little
excused.
bit.
Attorney Tang.
Present, Your Honor.
Attorney Bell.
Present.
Your Honor, Attorneys Little and Mason are appearing via Zoom.
Attorney Jackson's getting some free publicity as well.
Attorney Jackson.
Present.
Attorney Seligson.
Present.
And Attorney Rosenberg.
Present, Your Honor. You can sit down. Thank you. So thank you, counsel, for being here. I scheduled today to be in person because of the significance of what I was advised of last Friday. because I find the quiet solemnity of the courtroom is a good reminder of the dignity by which courts are supposed to function. One commenter describes how every
Well, maybe he always does
high-profile
this.
case now
Is he
unfolds
boosted?
in two arenas. One governed by procedure and precedent, and the other by pixels, edits, and algorithms, and how the courtroom has become content and the law has become a spectacle. I recently held a hearing on a non-party motion for a protective order. I required the moving party to provide certain information. Such material was filed together with a motion to impound. A hearing that included the motion to impound was held on a Monday morning. I allowed the motion to impound during the hearing. The affidavits of the moving party and the attorneys were impounded. Following that morning hearing, I found that there was insufficient information to support a delay in the deposition of the non-party from going forward. However, I further found that given the claims made in the filings, I would delay making a final decision on the motion until later that day to give the non-party's counsel the opportunity to supplement the record before me. I scheduled the matter for further hearing that afternoon at 4:15 with the expectation that there would be additional filings. At 2:22 p.m. that day, the non-party's attorney emailed the clerk of this court and all counsel of record, excepting one, additional materials in support of the motion for a protective order. The filing included a motion to impound additional materials. Exactly 30 minutes after the email to counsel of record of the additional material, which included sensitive and private medical information. Similar information to what was in the exhibits to the filing and marked provisionally impounded was posted to an X account at 2:52 p.m. Upon learning this information, I ordered that the parties and counsel provide a certification to the court as to all facts known to them as to any dissemination to anyone other than parties and counsel in this matter of any of the contents of the material impounded on June 8, 2026, and I scheduled this appearance for today. I received certifications from all party and counsel, 32 of them in total. No one apparently has disseminated, nor are they aware of any facts regarding the dissemination of the contents of impounded material to any person or entity other than the parties and counsel in this matter. However, somehow, an ex-account holder,
Give the name.
not part of this case, apparently received information that was at least provisionally impounded. Orders of the court have been violated either directly or at the very least in spirit. If these orders are to have any effect, all parties involved must operate with integrity. Rule 13C of the Uniform Rules of Impoundment Procedure imposes a duty on all persons to protect the confidentiality of impounded material. Additionally, Rule 3.6 of the Rules of Professional Conduct prohibits lawyers from making extrajudicial statements that they know or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. In cases like this, where all parties involved are aware of the public attention, I expect that everyone is taking every precaution to preserve confidential information, to follow the rules of the court, and to adhere to my orders. Because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. If necessary, I am fully prepared to make such order permanent as permitted by Rules 26 and 30. To any issue counsel may raise as to the management of discovery issues being within my discretion, I invite you to look at the following cases. In the 2003 case of Buster v. George W. Moore, Inc., 438 Mass. 635, the SJC stated at page 653, in general, discovery matters are committed to the sound discretion of the trial judge. In a 2002 appeals court case, Mattoon versus the City of Pittsfield, 56 Mass. Ave. Court 124, the court stated at page 131, trial judges have broad discretion to make discovery and evidentiary rulings conducive to the conduct of a fair and orderly trial. In the 1987 case of Solomon A. versus B. Gruhl, 399 Mass. 790, the SJC stated at page 799, the conduct and scope of discovery is within the sound discretion of the judge. In Cronin versus Strayer, 392 Mass. 525, a 1984 case, the SJC stated at pages 535 to 536, we remind judges that the scope and timing of discovery is within their discretion, and the prevention of discovery abuse is sufficient justification for the authorization of protective orders. With this authority at hand, judges should not hesitate to exercise appropriate control over the discovery process. And finally, in the 1987 case of Campagna versus the Board of Directors of the Massachusetts Housing Finance Agency, 399 Mass. 492, the SJC stated at page 503 that Rule 37 affords a judge broad discretion to impose whatever sanctions are just in order to ensure that the discovery process operates efficiently. The malicious publication of private information concerns me. Whatever opinion that one may have of a non-party, even if warranted, such an opinion does not allow for the disparate treatment of such individual. All people deserve fair and equal treatment in our system of justice, regardless of any personal characteristic, as abhorrent as some of them may be. What I am looking for is for the parties is adequate assurances that their discovery served justice and not any desire to weaponize the rules for pettiness and profit. If the parties and lawyers would enter into an agreement to hold private, personal information in confidence, and if the terms were acceptable to me, I would consider entering it as an order of the court so that any violation would be grounds for a contempt finding and appropriate sanction, including dismissal or default. Such an order would need to be more than a stipulation that deposition testimony can only be used for the purposes of this case. I encourage the attorneys to confer and to seek to reach an agreement. In the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking. My final request to counsel with an appearance in this matter is to familiarize yourself with Rule 3.6 of the Rules of Professional Conduct relative to publicity. The rule sets forth a basic general prohibition against a lawyer's making statements that the lawyer knows or should know will have a substantial likelihood on materially prejudicing an adjudicative proceeding. The rule applies to lawyers who are or have been involved in the investigation or litigation of a case and their associates. As the comment to the rule notes, it is difficult to strike a balance between protecting the right to a fair trial and safeguarding the right of free expression. However, preserving the right to a fair trial for everyone necessarily entails some containment of information that may be disseminated prior to trial, especially where trial by jury is involved. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence. The rule takes into consideration that the public has a legitimate interest in the conduct of judicial proceedings, particularly in matters of general public concern. However, I'm not so sure that churning the waters to generate social media coverage necessarily can result in a legitimate interest in the conduct of judicial proceedings. Read the rule, especially if you have never done so. Adhere to it, or be ready to face the consequences for failing to do so. I remind counsel of what one commentator called the quiet expectation of fairness that we have as citizens. Such expectation is based on the framework the founders of our country built 250 years ago and trusted future generations to maintain. Counsel, do your part to maintain the quiet expectation of fairness. Do not succumb to the attraction of seeking to influence this case through social media. Be what a trial lawyer should be, one that tries their case in the courtroom. And remember the provisions of General Laws, Chapter 221, Section 28, relative to the oath of office for an attorney in Massachusetts, which provides, in part, I solemnly swear that I will do no falsehood. I will delay no man for lucre or malice, but I will conduct myself in the office of an attorney within the courts according to the best of my knowledge and discretion, and with all good fidelity, as well to the courts as my clients. So help me God. I wish all of you a happy 4th of July on the anniversary of our America's 250-year-old democracy. May it continue to succeed with all of us working to maintain the rule of law. Thank you.
Court, all rise.
For the record, this matter is continued to July 10th, 2026 at 2 p.m. for hearing on motions to compel the criminal fourth session.
Court stands in recess.
There's no opportunity to be heard? There obviously no opportunity to be heard.
I was unaware. I'm just covering for clerk. None of it.
He's like, what?
Is there an opportunity before everybody departs to let the judge know that we would like to be heard?
I have.
There we go.
Wow.
Wait, don't do that, idiots. Maybe the
First-
other one.
Back and ask if the
Yeah.
judge would be willing to
Let me
hear.
check. Let me check Boston 10.
Yeah, we'll see if we can find it. If somebody's still got the
Oh,
stream.
it's back here. Okay. Nope, it's not.
Is that Boston 10?
Yeah.
We'll keep an eye on it because I'm sure if they come back, they'll fire it back up.
Yeah. All right. We'll see if this thing about the hearing, about the verdict. Oh wait, it's back.
Guilty.
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 All right, they're back. Hold on. Jeez, I gotta. Oh, Jesus.
Hurry, babe.
It's not. Now it went back to the other. I'm gonna put it up.
Just keep it up. Like we'll wait it out, or at least keep it up in our backstage.
Oh, in the backstage. Okay.
Yeah.
Well, since that's all it does for me anyway, we might as well just do that.
All right, trust us. If they come back, I'm gonna put Boston 10. I'm gonna look and see if that comes back as well. Let's see. So, yeah, he was the Blaze guy was found guilty. I think on all counts. As soon as he went down for the first one, I dipped because the judge was.
Oh, I can go into the thingy. I'm gonna go into the thingy.
The Zoom.
Yeah.
Do it.
Okay. Nobody
Don't
talk.
get Bob. Don't have an open mic.
No, it's all sorts of stuff.
Or Brad. Brandon was popping off quite a bit there yesterday too.
All right, here we go. I might not be able to talk because I'm really worried about this. Wait, do not connect my audio. Do turn off my video. That's what I want. Okay. What? Is he coming back?
I don't know.
Wait, why are we seeing? What are we seeing here? It says waiting for the host to start this webinar. Why are we seeing Melanie?
Where?
Oh, you're not seeing it backstage?
No. But my shit froze up. All right, I gotta dip out and come in real quick.
All right.
My Google occasionally freezes. It's weird. I can't click on any of the tabs.
All right, so I'm in the meeting now, and it says waiting for the host to start this webinar. So I'm just going to leave this up in case he restarts it. So, okay, in the meantime, I asked Grok, what are the posts closest to this? Okay. So we have an IDA _ Lee 32126 at 2. Oh, Bob left at 2:58. That said, well, that one's not that much, but there's a cat questions all at 2:55. Proctor delaying the inevitable. Has he checked into a mental institution yet? Because it's his only way of delaying at this point. And even then, it's a temporary delay. But I think we all kind of thought that what else are you to think when he's like, oh, I got this medical records and they're sealed and all these people chiming in. And then there's someone that says Christy 432222021 at 2:55 p.m. No wonder Proctor is not feeling well. He's not worried about the racist remarks. He's shitting himself because he knows the feds have it all. But so I guess the closest one would be this cat questions all. And it was replying to one of Aiden's posts, but Aiden's post was it was just this, and it was from 227. Whenever the McAlberts are backed into a corner and confronted with their shady behavior, they suddenly transform into victims of harassment. Michael Proctor did it again today. So that's it.
Not having any luck?
I mean, there's nothing happening on Zoom. It's not started. But I was reading, but I had Grok search for any posts at 2:52 p.m. Eastern time.
So here's my thought on it. If somebody posted it, it wouldn't still be up. Okay. First and foremost. And if somebody posted it and somebody's like, yo, dude, you got to pull that shit down, which is probably what would happen if somebody leaked a document. Because the judge said, because there's two trains of thought here, right? Either it happened or the far more, and I understand the argument, but it's far more unlikely is that the judge made this up out of whole cloth in order to make it
unlikely.
Unlikely in order to make a bigger point that he's trying to rein in.
No, I don't think he would do that.
That would be crazy.
He gave a time,
an exact time.
And I think the counsel had the right to know, that would want to know, Your Honor, we need to know who the X person is in case it's someone in our office.
Right. So what I would like to have seen. Now, the judge has the ability to be able to haul somebody in. If in fact this post existed, I would have thought if he was really interested in getting to the bottom of it, that he would have forced that party to come before the court, much like the judge in Koberger did when he was
Okay.
forcing Dateline to come in and tell him who provided the document.
Okay, wait a minute. Did the judge say 10:52 a.m.? Because Tracy just sent me a post from Aiden at 10:52
Yeah, I don't
a.m.,
know.
which I think was too early. The first
That's-
hearing,
He said 9:52 a.m.
I thought he said 2:52. So I'll have to go back and listen, but I'll share.
Wait, you posted the comment with the exact time.
That's what I thought he said. Well, let's go back and hear what he said.
Okay. I mean, if it's a situation wherein it's Grant or Turtle Boy, it then becomes very obvious who would have alerted the judge to it. It would have been a anti. Which one? I don't know.
You're
But
2:20. Listen. 2
Oh, we- here, we can't-
2:22 p.m.
we can't see it.
What? Jesus.
All
It's
right,
up there. I'm looking at it.
I just put it up.
Ay, ay, ay. 2:22, not
For
2:52.
further hearing that afternoon at 4:15.
He has
With the
misinformation.
expectation that there would be additional filings. At 2:22 p.m. that day, the non-party's attorney emailed the clerk of this court
Oh, no,
and all
2:22.
counsel of record, excepting one, additional materials in support of the motion for a protective order. The
2:52.
filing
He said it was
included
a
a
half
motion
hour
to
later.
impound additional materials. Exactly 30 minutes after the email to counsel of record of the additional material, which included sensitive and private medical information. Similar information to what was in the exhibits to the filing and marked provisionally impounded was posted to an X account at 2:52 p.m.
2:52.
Upon learning this information, I ordered that
Okay, so here's what Tracy sent me, and maybe the judge got bad information. I'm surprised he wouldn't be looking at a.
He indicated that somebody posted the document.
No.
Here,
In-
go back. I want to listen to
Similar information. All right, I'll go back.
it.
It's a pain in the ass. I need to figure out why StreamYard's doing this to me.
I'll put it up. Just throw
I
it in.
got it. Okay, then you share it.
Okay.
Okay.
found it was posted to an X
Oh,
account.
sorry.
And similar included sensitive and private medical information. Similar information to
Similar.
what was in the exhibits to the filing and marked provisionally impounded was posted to an X account at 2:52 p.m. Upon learning this information, I ordered that the parties and counsel
That's it.
provide a certification.
So,
All right. So, but I here, just keep it up because I think we should listen to it again.
okay,
So
well, let me put up this thing so that
Okay.
we know that is it, the question is it possible the judge is getting bad information? So this is 2:10:52 a.m. Michael Proctor decided to have a mental health crisis after the whole world find out how racist he is. Sources tell us he checked himself into a mental health facility in Florida to try to avoid today's deposition. They filed a motion at the last minute on Friday to delay the depo, but the judge wanted proof. They submitted an affidavit that was impounded because it likely said Proctor was in a mental hospital. Karen Reed's lawyer made the mistake of saying the scheduling of the deposition was strategic, which the judge took issue. So this is impossible that this was 10:52 a.m. Like literally impossible.
Is it the right day?
It's June 8th.
Hmm.
He stayed the deposition for 24 hours and at 4:15 a hearing will be held. So wait, what time was the morning call on June 8th? Does anyone know? I'm gonna try to figure it out, but does
Let
anyone
us know
know?
in chat. What time was the first hearing? Because he has the first hearing, and then he ends up calling them like he sets it for the 4:15. So was it at 2? Was there only that kind of a break? Or was it a morning call? I think this has to be the post he's talking about. It's a lot of intel.
Right.
It was Grant. He posted court docs at 2:52. Rissa, are they still up? What was it?
Let's see, wait. Wait a second. Look at this. He said, my guess is he's going to tell Proctor to jump on a plane and stop being such a P word so Alan can stop being such a limpy so Alan can depose him tomorrow, which is basically what the judge did.
Oh, I meant to tell you, one of our comments in our chat clarified that the P word is not referring
I
at
saw that.
all. Did you see that?
Yeah, but that's what people think nowadays anyway. I don't care how it started. That's what it is.
true. That's true. It's taken on a different meaning.
So it was Grant. He posted court docs at 2:52. Risa, somebody have those?
Are they still up? I mean, you could just let me check Grant's count.
And I've got the docket up, so let me see what time the first hearing was. I'll pull it. I'll share it for you guys. I'll share with you. All right, babe, share it.
Hold on. All right.
Okay.
I got it.
All right. So 8:45 a.m.
So that would be more in line with Aiden's thing. Well, let me see what Grant posted on the 8th. Okay, so Aiden, just 5 minutes ago, Aiden says this was a 2:52 tweet reporting. Here, let me, do you want me to share this?
Yeah.
Okay. All right, let me share this guy here. Let me just get this guy over to.
I've got X up.
I'm already here. I'll just share it. Plus my share screen's working properly. All right, share screen. All right, okay.
So the hearing was 8:45 in the morning.
Oh yeah, you know what? My shit's doing the exact same thing. Like it's not automatically going to the
I did it for you.
I know, but like I don't know if StreamYard, like what I'm saying, it's doing the same thing.
Right now, I get it.
Yeah. All right. So
we can't see any of that. Can you blow it up?
Yes, dear. All right. So Aiden says this was at 2:52. Tweet reporting what happened in court that day. And then so Grant said Michael Proctor has submitted 2 exhibits, an affidavit from his lawyer and medical documents in his last-ditch effort to delay being deposed by Karen Reed's legal team, including Alan Jackson. The judge will be holding a hearing at 4:15. So, I mean, he just posted the documents that were filed.
Makes no sense.
And let's see, within that, all he did was name what was listed in the motion, the attorney's affidavit and the medical documentation. So I don't see an issue with that. That ain't it.
I'm like, Grok, what the hell happened? Here, what about Grant Smith Ellis's post? Oh, yeah.
Oh, yeah.
The AI sucks. Michael
sucks.
Proctor has submitted 2 exhibits, an affidavit from his lawyer and medical documents in his last-ditch effort to delay being deposed by Karen Reed. Was it on is it file stamped? Yep.
Yeah.
What time?
2:22 p.m. So exactly 30 minutes later.
So I don't know. So he's out of his mind, this judge.
Well, that's much ado about nothing.
Much ado about nothing.
Much ado about nothing. Because
And I
that ain't
promised
it.
the people, if this was much ado about nothing, which it is, that we would talk about good. So it's up to you whether we need to
So
create.
wait, no, but I want to go because it is in terms of what he's claiming happened as much ado about nothing. What he's talking about doing, I want to go back and
And
watch. I
listen
don't
to
know
it.
if you were
Got it.
paying
No, I
attention.
wasn't. I was trying to find
Yeah, well, you're gonna want to hear it.
all right, let's
Not,
go
and I'm
back
not
and
talking
listen.
about Rule 3.6. The things that he wants. Well, we'll just listen to the judge and then we'll discuss because it's pretty shocking. Like he's really trying to rein in. He is trying to shield this case completely from social media.
Well, I can't believe he made them leave without anybody being able to say anything. Or
Yeah.
maybe
Can
they
you
did.
pull it back up the stream so we can listen?
It's
to
up. So
Oh,
hit the button.
oh yeah. All right.
We got to double team this.
Yep.
All right.
To the court as to all facts known to them in this matter. I received certified examination of the other than the parties. An ex-account holder, not part of this case, apparently received information that was at least provisionally impounded.
Yeah, the motion.
Orders of the court have been violated either directly or at
I
the very
disagree.
least in spirit. If these orders are to have any effect, all parties involved must operate with integrity. Rule 13C of the Uniform Rules of Impoundment Procedure imposes a duty on all persons to protect the confidentiality of impounded material. Additionally, Rule 3.6 of the Rules of Professional Conduct prohibits lawyers from making extrajudicial statements that they know or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. In cases like this, where all parties involved are aware of the public attention, I expect that everyone is taking every precaution to preserve confidential information, to follow the rules of the court, and to adhere to my orders. Because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. If necessary, I am fully prepared to make such order permanent.
Listen, you're not listening to the part I wanted you to
Okay,
listen
got it.
to.
Got it.
Yeah,
All right, here we go.
rewind it.
Okay.
If necessary, I am fully prepared to make such order permanent as permitted by Rules 26 and 30. To any issue counsel may raise as to the management of discovery issues being within my discretion, I invite you to look at the following cases. In the 2003 case of Buster v. George W. Moore, Inc., 438 Mass 635, the SJC stated at page 653, in general, discovery matters are committed to the sound discretion of the trial judge. In a 2002 appeals court case, Mattoon versus the City of Pittsfield, 56 Mass Ave Court 124, the court stated at page 131, trial judges have broad discretion to make discovery and evidentiary rulings conducive to the conduct of a fair and orderly trial. In the 1987 case of Solomon A. versus B. Gruel, 399 Mass 790, the SJC stated at page 799, the conduct and scope of discovery is within the sound discretion of the judge. In Cronin versus Strayer, 392 Mass 525, a 1984 case, the SJC stated at pages 535 to 536, we remind judges that the scope and timing of discovery is within their discretion, and the prevention of discovery abuse is sufficient justification for the authorization of protective orders. With this authority at hand, judges should not hesitate to exercise appropriate control over the discovery process. And finally, in the 1987 case of Campagna versus the Board of Directors of the Massachusetts Housing Finance Agency, 399 Mass 492, the SJC stated at page 503 that Rule 37 affords a judge broad discretion to impose whatever sanctions are just in order to ensure that the discovery process operates efficiently. The malicious publication of private information concerns me. Whatever opinion that one may have of a non-party, even if warranted, such an opinion does not allow for the disparate treatment of such individuals. All people deserve fair and equal treatment in our system of justice, regardless of any personal characteristic, as abhorrent as some of them may be. What I am looking for is for the parties is adequate assurances that their discovery served justice and not any desire to weaponize the rules for pettiness and profit. If the parties and lawyers would enter into an agreement to hold private, personal information in confidence, and if the terms were acceptable to me, I would consider entering it as an order of the court so that any violation would be grounds for a contempt finding and appropriate sanction, including dismissal or default. Such an order would
Yes.
need to be more than a stipulation that deposition testimony can only be used for the purposes of this case. I encourage the attorneys to confer and to seek to reach an agreement. In the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking. My final request to counsel with an appearance in this matter is to familiarize yourself with Rule 3.6 of the Rules of Professional Conduct relative to.
All right. So, yeah, let's explain to the people what the judge is trying to do here.
I mean,
He's
it's a
trying to
lot.
shut it down.
He's trying to shut it down.
He's trying to close access to any of the discovery in this matter. We're going to impound it all. I mean, I don't even know if he would if motions for summary judgment, if he's going to allow them to like cite directly to depositions. He said, except used in this case, but
Right.
they're not using it outside of the case. So what exactly is he? And if all of this is based on some bullshit that he got wrong, then I don't know what he's talking about.
Yeah, I think he owes it to the attorneys to make the record clear. If I were Karen Reed's attorneys and the Reeds or the O'Keefe's attorneys as well, I would want this, what appears to be what he's talking about, which is Grant's post, read into the record. I'd want this to be made a part of the record saying, Michael Proctor has submitted 2 exhibits, an affidavit from his lawyer, and, quote, medical documents in his last-ditch effort to delay being deposed by Karen Reed's legal team, including Alan Jackson, and then that the judge will be holding a hearing at 4:15. And then all he included was the actual motion itself, which was not impounded. And within that particular motion, within the very first paragraph, it says non-party witness Michael Proctor hereby moves to provisionally impound Exhibit A, affidavit of Matthew J. Hamill, and B, medical documentation. All he did was restate what the motion itself, which was not impounded, stated in the body of the document. That is not a leak. That is outrageous that he's trying. Either he got bad intel, but shame on him if he didn't double check. I mean, I'm assuming he pulled up the post, right? Or
You would
just
think
take
so.
that on somebody's
Somebody
word.
tells you, because if he's talking about Aiden's, obviously a post at 10:52 is before hours before they even filed the new affidavit with more information. So
I mean, frankly, Aiden had way more intel than Grant did 4 hours later in terms of what was going on with Proctor, right? Because Aiden's post was at 10:52.
I mean,
So
I
that-
was going to get on X and try and dig because there's other ways to search. I can try to search for the word Proctor on this date, and but I didn't want to start doing it right now. That's why I was like, oh, I'll just ask Grok. But Grok, sucks. So you know, I mean, but so the judge is saying if they don't agree, he's
Yes.
just gonna do it anyway in his plenary authority.
Well, explain to him what he's talking. He's talking about, like, I don't know. He's essentially gagging the case without gagging the case. He's like essentially gagging the lawyers without gagging them through a court order at
And
this point.
what does what does he define as personal information? Obviously, whether a man went into a mental hospital and anything related to that is personal information, but what other personal information does he think's going to come out of depositions that he doesn't want anyone to hear about and that the lawyers have to promise to keep private?
Well, it's like you said, babe, when we get to the summary judgment phase of this case, which it 100% will be getting to in the near future as discovery is ending in whatever that August date is. And the next thing they're going to be doing, they're going to start drafting their motions for summary judgment. Each side will have time to respond. And then a hearing is going to be set in which they will argue their motions. And the judge is going to make a decision. But within those motions for summary judgment, if you were with us last night, Allie was telling you that is where we are going to get the most juicy details of what was disclosed in depositions, interrogatories, production requests, because basically you're supplementing your motion with the evidence that you've gathered saying, look, this is an issue of law. This isn't an issue of fact. This doesn't go to a finder of fact. This is going to be ruled on by your honor, and this case goes away. So, when that happens, I mean, you're right. Is the judge going to try to impound the motions for summary judgment? Because that'll suck. That'll
Right.
suck. Allie wasn't listening to me.
Trying to see if
I know, but I was trying to have a discussion. Now I'm going to go cry.
this meeting could close down. Like, just want to make sure that somehow it's not back up.
I mean, that's like look, I understand and appreciate the judge taking control of what he views as an out of control situation or a situation that is on the verge of being out of control. I don't see it that way. I don't think anything of substance has been leaked at all since the beginning of this thing. And, as to Proctor in particular.
Wait, shh. Something's happening.
Oh, exciting. What are you in? Zoom? Put it up. Put it up.
When you had that echo earlier, you have to slide this all the way down.
Oh,
That's where I was coming from.
appreciate that. Is anything else happen over here? Do I do the video or something?
Headset.
Stay on. Is that the judge?
Just the judge talking to his clerk about all the technical.
You want to look at the people that are on Zoom,
Yeah, they're just talking.
Okay, quit talking.
No, they're talking about technical shit. I'm getting off.
Yeah.
Video lunchtime?
I got off. I mean, God forbid he heard that. He's in there. He's like, you just fuck around with the video, or because the guy's like, oh, you want to see the people that are on Zoom too. So they're just like fucking around with the
Well, the bigger problem is that they could still see who was in Zoom.
Right,
If
they should have.
they're eavesdropping, then they're gonna hunt them down. All right, so I just, as much as I wanted to sit there and listen to it,
No, I was.
that would have been a real easy find.
Yeah,
Who's this
attorney Allison Mata. Right.
Yeah. So, yeah, what I was saying though, this thing is, I mean, he's he's trying to rein in a situation that I think he is just anticipating is going to get like the criminal trial. And I just don't see it that way. Like the passion for a civil case just will never rise to the level of the criminal case just because freedom is not at stake. When you're talking about a civil case, you're talking about money damages. Now, I get that Alan and Karen have publicly stated, look, we don't give a shit about the money. We're trying to provide justice for John O'Keefe. We're going to use the civil process in order to establish by a preponderance of the evidence, which is the standard, the legal standard in the civil case, that the people that were inside that house were responsible in some way, shape, or form for John O'Keefe's death. I get that. And maybe they get there. I don't know. I mean, it's certainly not going to. The one thing that I want to tell you is let's fast forward in a totally, this is a absolute guess, or it's just a hypothetical. And let's assume that Karen prevails and that a jury comes back and finds by a preponderance of the evidence that the people inside that house were in some form or fashion responsible for John O'Keefe's death. And at that point, the question.
Well, she doesn't need to prove that, though.
I thought she countersued. I thought there was a countersuit where she's exactly trying to prove that. Maybe I'm wrong because we haven't covered it.
I could be wrong too. Maybe
but
she did.
I'm fairly certain she
hard to prove.
Well, it's like the problem is always going to go back into that thing that I was screaming about 3 nights ago when I was talking about the investigation. Nothing's ever going to make the investigation better than what it was. What needs to happen, the only thing that can ever happen is somebody caves, somebody folds, somebody with knowledge comes clean. That is the only way, no matter what happens in the civil case, if you're of the mindset that if it came down that by a preponderance of the evidence, or if people look at the fact that they don't find that Karen is liable for defamation as kind of a signal towards the fact that, okay, we believe that Karen is factually innocent. And what that means, all it can mean, is that something happened inside that house. And they're hoping that that turns into criminal charges. It's not going to happen because they still don't have the evidence. Because
they're never going to admit that they've got it wrong. Anyway. And so I stand with Mel says.
Oh, you mean the Commonwealth itself?
The Commonwealth,
yeah,
right. The only person who pandered to the media today was the judge. I mean, basically, that was Bob and I's position
last night
when we were going over it. And then I was wondering today, does he always talk like this? Because that was part of like his whole opening with a quote and, I don't know. Maybe he does always, but it definitely seemed to us that he was pandering to the media, that he was the one like doing theatrics with his orders and the way he wrote it and what he said. And, and then today, like not even allowing them to speak
was weird.
All them across the country.
Yeah. Alan must have been thrilled.
Well, he would have never come if he had known that he was just coming to be spoken to. I mean, who holds a court like that? You don't make an allegation like that. Say that you're going to use your plenary power to basically gag discovery. So because of something that occurred, and then not give anyone the opportunity to say a thing. I can tell you something. I'm fairly certain that Alan Jackson's going to file something, because I can't imagine that he appreciates that not being heard at all. At all. So is this the same judge that says words like, because I thought it was, I thought he looked different or sounded different. I don't know. Maybe I wasn't seeing the judge's face before, and that was the issue because we were looking at the Zoom screen. when he's like, well, here's the way it works. So I say words and I rule, and you shut the fuck up and don't say a word. I mean, that's what he said in the last hearing that they were in.
Right.
When another one of Karen Reed's lawyers was trying to speak and be like, you're trying to force us to give notice to Proctor's lawyer before we file a complaint against other defendants? What? And you're saying you find that unreasonable? What? I think I find that unreasonable. I find completely unreasonable that the judge finds it unreasonable that Karen Reed's lawyers aren't going to share their complaint before it's even filed. Just share it with, some random
Who's
non-party.
not a party to that complaint.
Right.
Right. It's crazy. You have no obligation to send that complaint to Proctor's lawyer ahead of time of his
And I'm
death.
saying random because I'm prone to exaggeration. Obviously, he's not random, but I'm just saying a non-party. No, why?
Yeah.
I would never in a million years even think to do that. Even think to do it. Like, why? I mean, I almost never give the other side a copy of the complaint. You don't show the only time you show like the plaintiffs, the defendants, what you're about to file is if you're like, look, you better settle with me now because this is the shit I'm about to file on your ass. Like it was absurd. And now he's got this pattern of just refusing to allow the lawyers to speak. Just refusing to allow the lawyers to say anything about his, outrageous position. And then he's going to go on this whole thing that y'all are either going to agree or I'm going to use my plenary power. And I wrote down the two rules that he mentioned. I texted them. I was trying to get some of those sites, but I was also trying to listen. So let's just see Massachusetts rule. Civil procedure. What was it? 26. General provisions governing discovery. Okay. And then you've got C, protective orders. So let's just. I got to do the double step to come back and put it back up. All right. So. Wait. Didn't I do this already? Protective orders.
My thing is him electing to do it with respect to this particular non-party witness gives me a bad taste in my mouth. Like anybody else other than Proctor, because you know what I immediately start thinking is, who are we protecting?
Why
here?
exactly? Why are we still?
What are we protecting? Why are we protecting Michael Proctor? He sucks. Like, I'm not going to get into the rant again, but why are we protecting this guy? Because that's what this feels like. I can't help but feel any other way other than because it happened to be with Michael Proctor. Like frankly, where I'm at with this is I want to know more. I want to know what the judge thought. He owes it to the attorneys. I agree, babe. The attorneys need to get something on the record. I would make sure that the judge is putting on the record what his allegation is. Like, I need clarification, Judge, because here's what I'm going to put on the record. I'm going to read the only post that I could find from anybody that was posting about that matter on that day at that time, which was Grant Ellis. And all he did was post a motion that was not impounded. And all he did was mimic the language that was actually in the motion itself.
And
that in by no way, shape, or form is a leak, Judge. So maybe I'm missing something here. Are we talking about that post?
Right, because it sounds like the judge thinks the public is stupid, that we can't read between the lines of what was being said in the morning hearing. And
yeah, he's I don't know.
Like we all could tell, it's right there. It's right there for you. And so here,
do you think this is just him like over flexing his power? You know what
I
I
don't
mean? Like,
know.
that's kind of what it's
I
either.
wonder I wonder if he lives in a anti-Karen Reid house.
I mean, who knows? Like, but in terms of his, I looked him up. The guy went to Georgetown for undergraduate. You know,
He's
he was a civil defense attorney for years. He understands civil law. He understands the process. And as far as I know, he's been, a civil judge the entire time he's been on the bench, which is around maybe just shy of 10 years or
100
just
years?
over. No, he's been on the bench, I think,
Kidding.
for like 10 or so years. I can't remember exactly. So he's not a neophyte judge. He's not in over his skis. So in that sense, you have to wonder what the motivation is here. And it's curious.
It is curious.
I don't know. And
But let's look to the rules that he's mentioning and the powers that he's talking about having here. So where the okay, to make any order which justice requires to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense, including one or more of the following: one, that discovery not be had; two, that the discovery may be had only on the specific terms and conditions, including a designation of time, place, and manner, and sharing of costs; three, that discovery may be had only by a method of discovery other than that selected by the party seeking discovery. That discovery may be had only by a method of discovery other than that selected by the party seeking discovery. Four, that certain matters not be inquired into, or that the scope of discovery be limited to certain matters. Five, that discovery be conducted with no one present except persons designated by court. With no one present except persons designated by the court. We've been talking about this all along. Now, obviously, this is not one of the cases that Aiden's a party to, you know, but I'm sure Karen wants to be present for depositions. I don't know. Maybe not. Maybe I don't know if has there been any reports out there of whether Karen has been present for any depositions?
if I were Karen, I'd be present for all of them.
Me too, but I can guarantee that Aiden plans to be present for his. I mean, I guess I can't guarantee, but I just
Wait, what do you
feel like
mean?
he
Of
would.
course he's going to be present for his. He's going to be the deponent. What do you
No, I
mean?
mean for the ones taken in the case where he's a party,
Oh, yeah.
because that's a different judge, and so he's not subject to this. So I'm just sort of I was just throwing that out there
Yeah,
here,
for
but
sure.
let's not
For
confuse
sure.
people, I guess. So that's
The question now becomes, will that judge try to mimic what this judge is doing? Because if there's not some kind of language, Aiden is running to his computer after those depositions and spilling the beans, which I'm here for. like if there's no prohibition for it, go.
Well, there's not been one in the past. So then it says 6, that a deposition after being sealed be opened only by the order of the court. 7, that trade secrets or other confidential research, that one doesn't matter. 8, that the parties simultaneously file specified documents or information enclosed in sealed envelopes to be opened as directed by the court. Factors bearing on the decision of whether discovery imposes an undue burden or expense may include the following: one, whether it is possible to obtain the information from another source, okay, whether it's unreasonable, cumulative, or duplicative, and whether the likely burden or expense of the proposed discovery outweighs the likely benefit of its receipt, taking into account the party's relative access to the information, the amount of the controversy. So none of those really apply here, as far as undue burden and expense, but there's also embarrassment, oppression, annoyance. So if the motion for protective order is denied in whole or in part, the court may, on such terms and conditions are just, order that any party or person provide or permit discovery. So upon motion of the party or by a person whom discovery is sought, this is what it says. Upon motion by a party, I mean, I guess that person obviously could be Michael Proctor. So now let's just see it was, so this was 26 and we need 30. Why is there's not one of these things like go to the next one? All right, 30. That's the other rule. So so this one doesn't have a specific protective order. So I don't know what oh, there's more. Okay. Oh, none of those are relevant either. So I don't know why he was citing 30, what he planned to do, what he was thinking or threatening to do here.
Yeah. Well, I think our answer as to why he did not allow the attorneys to make any kind of statement was because he knew. I mean, what would you have done? The first thing I would have done is said, Your Honor, with all due respect, we could use a little bit more. Now, I don't know that the judge, I mean, I'm assuming the judge has not told them beyond what we just heard exactly what this alleged leak was and what it said.
Right.
But if I'm the attorney of record and you're, of course, always concerned about preserving your appellate rights, I'm asking him flat out on the record, what are you talking about? Can we have some specifics beyond a time and some kind of nefarious X account? Which
Yeah,
could
I
be,
think you're right. I think he could do a motion for clarification or additional information, and he could say, "This is what we found. This one has nothing to do with anything," like you said, the Grant Ellis Smith one, and if there is something else we need to know, and they could put it under the guise of, because if one of the staff in one of these firms leaked this information, we need to sniff that out, and we can only do that if we know what was given and the identity of the X account that posted it. So we can figure out who the person is and if they have any relation to anybody that had any access to any of these documents, period. Anyone in any of the offices of any of the lawyers.
yeah.
Katie did it, she did, says only the state may leak information without getting smacked. For sure.
I mean, in criminal cases, right? Like,
Right.
I want to, it gets hard as you kind of get into these civil cases where the spine of that case is a criminal case that took place.
And
And
public
not
corruption.
confuse the two. Yeah, right. I
No,
mean,
I don't think that she is. I think she's just saying
no,
like we
I'm
see it.
talking about in
Oh.
general. Like it's like even myself when I was watching before we even had a YouTube channel, when I was watching Depp versus Heard on various YouTubers channels, I would see people in the chat talking about guilty. I'm like, no, this is a civil matter. But there was so much discussion about alleged domestic abuse and all the things that were going on in that relationship. It had the feeling of a criminal trial, So it's like, I think that people sometimes kind of lose sight that we're in a civil case. Again, freedom is not at stake. This is money. No matter what your motive is in filing, the end of the day, what you get in civil suits, if a party is found liable, is money.
Right.
If you gain satisfaction from that, awesome. If you're doing it for the principle of the thing and you prevail on it, awesome. That's cool. But at the end of the day, we're not discussing liberty. We're discussing cash, so it's a different beast. But it's interesting. I think I'd like to see what the rules are with respect to Massachusetts and their civil statutes regarding discovery.
So and here's the thing I wanted to what do you mean? We were just looking at them.
Oh, like I was writing a post, so I was doing what you do, not paying any attention.
So but and I'll read I stand with Mel's first because I put it up there. This judge is making a mountain out of a molehill. June 8th text. I think that was Aiden's post about the panic attack. Geez, judge, he had a panic attack in a public place. She did make this comment earlier, like while we were listening. So
I agree with her completely. And I think that he confused the two. Because
well, he's talking about the other.
Ellis's thing is nothing.
Right, but she's talking about this was whenever his deposition actually occurred that Aiden made a post about the panic attack that happened in a public place.
What day did he get deposed? The 9th?
No. I
What day
forget.
so that wasn't even the same day.
No.
Oh.
But there was that other one that we put up that was the same day. So I was going to say this. So I represented I was in an action against Robert Kelly, in a civil action against Robert Kelly. And the action
known
was
as R. Kelly.
right. I never call him that.
I
Right.
understand, but just to give people context in case they didn't know.
Right. So, and it was sealed. His entire it's his divorce proceeding, child support, child custody, all of that. And it was under seal. The entire case was under seal. Like nothing was public. And all of the TV stations came in and filed motions demanding that it be public and that, they can only seal when, under certain, when certain requirements are met, and they unsealed a lot of the case. And then we had to go through certain documents and like extract certain things. But I mean, there's a lot more reason, where you're talking about a case with public corruption, a civil case that involves public corruption, that it should be unsealed. I mean, I know it's not sealed, but that it should be open and accessible to the public than there is in some musicians, like actual personal private divorce matter,
Yeah.
Um,
I don't see any reason when we're talking again about money and not liberty, where there's no constitutional issues in terms of somebody getting a fair trial hanging in the balance, that there's anything being gagged at all. I mean, it's one thing to talk about somebody's medical records. There's laws in place. HIPAA, is very clear about that. We have an expectation of privacy in our in our medical history and what's going on with us personally. But as far as anything else, I'm not seeing it. What is he so concerned about? Like he's concerned that they're going to taint the jury pool in a civil case.
I do agree. Like Char MC, I don't know if it's like Charmac or Charmick. I absolutely agree. Take the fact that it's Proctor out of the picture, even with it being Proctor. I think Bob and I both wholeheartedly agree that it is 1,000% reasonable that a non-party's medical records are kept under wraps. There's
That's
no
literally what I just said.
right,
Yeah,
no
100% agree.
doubt, no question.
Yep.
Proctor, everyone, and the judge's points well taken, regardless how disgusting you may think someone is. Like there's certain information that just stays private, but he's trying to
100%.
take this to a whole different level.
Right.
Now the judge is trying to take this to a whole different level. I mean,
He's used that issue, which is correct, as a springboard to shut it all down. He in this judge's world, what he wants to see on the internet, in social media regarding this case is nothing, which is not going to happen. Welcome to the Karen Reed case, Your Honor. That's never happening. Like content creators are going to be making content. People that stand with Karen are going to be posting and reading posts and replying to posts. That's never going away. Like he's just got to understand that. And there's nothing that he can do that's going to be able to silence the people from talking about this case.
And the irony of it all, as Cammie points out, I agree. We don't want to share medical issues like Proctor does. I mean, his whole leaky balloon knot and all the irony of it all. But here's the thing, Your Honor, you know what? Maybe you're kind of older and you still have this huge stigma on mental health treatment. It's not that stigmatized. It's not that big of a fucking deal. Like, yeah, if he's shitting his pants in a mental hospital, and that was like the actual information. He's in an insane asylum shitting his pants uncontrollably, as Bob, predicted yesterday, jokingly. Then maybe there's some details you don't need. But the fact that people are out here talking about the guy having a mental health crisis, it's not all that. It's not the end of the world. It's not like some deep family secret. The man exposed his damn self. The man exposed his damn self with his texts and his racism and all of his misogyny and all of it. He exposed his damn self. So, I don't know if what the judge is really upset about is that all that information got published in the complaint in the first place, in a complaint in a different matter. Like, I don't know, because he was quick to hop on that in the June 8th hearing and to say, well, I saw you on the Today Show talking about you always plan to file that action. Why are you so worried about that action? The man has to be held accountable for his words. He was put in a place of authority in a community and given not only a badge and a gun, but enough trust and power to lock people up at fucking will. At fucking will. He outed his damn self. So, yes, Bob and I wholeheartedly agree. His medical information should be sealed. But the fact that he's having a mental health crisis and as a result can't appear for his deposition, oh, well, so what? That's not a big deal. That fact in and of itself was essentially, when you read between the lines, shown. That's why we went through it yesterday. What else was any logical person to assume? And
Yeah.
and look, this case is not only a Massachusetts case. People in Florida, guess what? Have heard about this case. So it could have been someone in Florida reaching out to Turtle Boy, like, hey, look, I just saw checking into a mental, if that's even what happened. Like, I don't even know if that's what happened, but
Yeah.
people tell him shit and he knew it before they filed it. So,
Definitely. Yeah, I agree, obviously, with everything you said.
Were we buffering?
No, but Cigarette Hush, number one, thank you for the $5. What I'm unaware, what is the Empire State Building trespassers? I don't know what it is. Now I'm curious. I'm curious.
So
It's
now
something I'm assuming it's Googleable.
You have to pay attention now to the
But thank you again.
comments.
I'll look that up.
I'm going to tell you.
Jody, thank you very much for being a member for 7 months. And then Jody followed up with saying it was Grant Smith Ellis. I think I sent the link in chat. Thank you very much.
People, let us know. Thank you.
In fact, get that.
I mean,
Bay
you're
Harbor
wrong.
Beauty Unfiltered. Ooh, love it. Welcome.
And
Family
Aaron
hug.
needs a family hug too.
Oh, family
Aaron
hug for
Ruggiero.
both these.
So Edward Kirkpatrick says Aiden has a post at 252 UTC that has stuff, but also he was posting about mental hospital before this. So yeah, and we put that
Did
up.
we find the 252 post?
I
'Cause that
didn't
was
see
1052.
Right. No, well, he says he has a post at 252, but that's UTC. I don't think the judge is using UTC, Universal Time Code.
Well, no, because he said it was 30 minutes after
Right.
the shit was founded.
And then, but he also was posting the mental hospital before this. Yes. I stand with Mel says the judge is going by X now. Told you, journalism with good sources are a reason to call in attorneys. Can the judge peck away at the fact that the McAlberts are dodging depositions since this judge doesn't take any shit? Right. I mean,
Look, here's the deal. Is for where we stand right now, and I don't know what the discovery deadline date is, but he references it all the time. This is expedited discovery. The judge is moving this case along, which is his role. That is one of his hats that he has to wear, is to get this thing moving towards litigation. We're not going to let this thing fester forever. If it's going to be a situation where they're dodging depths, he's going to bar their testimony at some point. Like the judge has the ability to do things like he was threatening to do with Proctor. Like I have half a mind not to allow you to depose him anymore. You know, I mean, those are things that
Did
he has
he
the
still
ability.
I can't remember. Did he say he was not allowing this to go forward
No,
temporarily?
like he made a threat. Like we could put it back up because like I don't wouldn't mind hearing his exact language because I mean he made a threat about, you know, but I can't remember if something continues to happen or, you know, I have half a mind to, if it was that kind of thing. So I like there's certainly they did not address when in fact Proctor would be redeposed at all. Now, maybe that's part and parcel of whatever was impounded, that he's not in a position at this point in time to be able to be deposed. I don't know. But again, I mean, there's nothing on the record with the judge saying, okay, now since this deposition was interrupted by the deponent having to take leave of it, I'm looking at what was impounded and I find that it's sufficient enough for him to not attend the deposition, and thereby I'm forcing the Reed team, the lawyers, to readjust their strategic setting of depositions in terms of what order they want to do them in. I mean, that like when did he say the next day was? Like July 23rd, 26th, something like that. So, but I
Let me
mean, look,
check
there's
that.
going to be like in the interim, we are assured that there are going to be multiple filings. I am quite certain that Karen's attorneys are running back to the office to prepare what Allie was talking about, like a motion for clarification, for additional information, whatever the case may be. They're going to put something on the record that they need more. We need more than what you gave us at the hearing, you know, because you're making big threats here, and you're trying to get, you know what it felt like, to be honest with you, without him actually gagging the case. It felt like what Judge Elmore did in the Spencer case when she issued that gag order that gagged the world from talking about the Aaron Spencer case, which of course the Arkansas Supreme Court roundly rejected and chastised her in that motion, in their opinion rather. And, you know, that gag went away with the quickness. So, you know, like that's why I was saying, babe, what do you think? How far can he go with gagging information in a civil case?
Well, that's why I brought up the
R.
Robert Kelly
Kelly
case.
stuff.
Right, because, you know, and it
But
had
that
been
was
like that
already
for
gagged
years.
before you came, right?
Right, it had been like that for years, and
Yeah,
then
since
when
the
I got
divorce.
involved, and I think it was, like, shortly before I had him held in contempt of court and arrested, or maybe it was after that. Maybe it was after that, that they were like, "Holy shit, what's going on over here?"
She hauled you into court to answer for something that you had put out, and you had, I remember that you had to go in there and make a whole argument about whatever it was that you, and I think it was in a pleading. Obviously, I don't think it was something that you said.
Yeah, because, you know, his own wife couldn't speak about it.
Yeah.
She couldn't speak about it. They entered into a divorce decree that forbade her from talking about what he did to her in their marriage, and whether he was paying child support or not, and how much child support he owed, and how, you know, like, what he was doing with his children. She was barred from talking about her own life, you know? So, it was, like, ridiculous, you know, that whatever lawyer allowed, you know, that to happen, that man should warrant, like, none of my dirty laundry can be public because I make music and people wanna know about my dirty laundry.
And I urinate on young girls. Like, fuck that guy. Like he was what a scumbag. Like he was the same thing. He was Proctor-esque, except like he was abusing young women. So Palmyra Media, thank you very much for the 10. Oh my God, you guys, love you, but you are giving me heart palpitations, need to attend our MCN beginning CC class. Lawyers suck at tech. LOL. Never a truer word spoken. Like,
Right.
I mean, Allie's usually pretty decent with tech. I'm not great with tech at all. I mean, I've gotten to the point where I'm competent on StreamYard. I'm certainly not great at making shorts and like editing and doing shit like that. Like I could really use a class, to be honest with you.
Well,
But
and
thank you so
Aaron
much,
says, and
Elmira.
I've got it booted up. I'm about to replay some stuff with the judge. I just want to get through some of your comments. Aaron said, I checked to see, and again, this was earlier, like 2:40. If it was Aiden, he did post about that MP was in Michael Proctor was in a Florida mental health facility right after the hearing on 6/8. But he said sources, the assumption will be, and she's saying like that this judge would assume that it was from the Reed camp, but it was before the Reed camp had that additional
Info.
information.
Right.
Right.
That was
So
it. Like that was the one that was at 10:52 a.m. Like that
right,
was where you pulled up the docket and looked to see what time the morning hearing was, and it was
right.
set for
8:45.
8:45, and they
Right.
started it late. So Aiden got intel from somebody, like Allie was saying. Like if it's true, what's to say it's not somebody who is living in Florida
Or
and
someone
follows the
here that
terms,
knows him, knows he went to Florida. We
whatever
don't
the
even know
case
if he
may
really
be.
went to Florida, but assuming that that was accurate.
Right.
Right. Nick
Right.
Starro says, and hey, Nick, that he went back to his feed that day and the rumors about Proctor in the loony bin started around noon, other than Aiden's, which was around 10:52, but he's got different time there.
Yeah.
Corruption continues, Hope says. In my opinion, Morrissey got to this judge. Grr.
But like Morrissey's got nothing to gain from the civil litigation. Like if they found that if they come back and find that Karen's liable, nothing changes other than she's going to appeal whatever award they give the O'Keefe family or the House defendants, whatever the case may be. I mean, like the appellate process in civil litigation is much like in criminal. You're going to file an appeal. If there's a judgment for money, you don't pay that money out. You go and you file an appeal and say, look, there were issues here and these are what the issues were. And, so like at the end of the day, like Morrissey's got nothing to gain. Like Morrissey's not going to go and have a press conference and talk about, oh, yeah, they found, by a preponderance of the evidence that Karen Reed, in essence, did this. I guess like he's got like that would be the most ridiculous press conference I've ever seen. He'd be a laughing stock because it
Right.
would just reek of desperation.
Reek, kind of like D Nice's reference here. Thank you. Does this mean that shit your pants man doesn't have to sit for a deposition? And I got that booted up. We're about to play it. And then Edward Kirkpatrick came back and said Aiden's post translates to 2:52 p.m. UTC.
Mm,
Money judge got a link that stripped the time conversion. That could be true.
that could be true.
See, the
So are you
10
saying that too? Because it is curious that it
that it
was
was
at
10:52.
52. Yeah.
Right.
Yeah.
So maybe if that's accurate, that very well could be the whole confusion here.
I'm not going to argue with you.
It sounds
Edward.
really good.
Sounds right.
If 2:52 and 10:52, if 10:52 Eastern Daylight Time is
Somebody who knows
2:52,
something about UTC, figure
you
it
can
out.
Google it, but I don't have time right this second
I
because I got
can't
it.
Google. What's
So
Google?
Jordy says, Bob, check the community page, please. So
Yes,
check
ma'am.
that while I go through
On it.
these.
On it.
I stand with Mel. Melanie Little cannot believe what she is hearing. LOL. I am toggling back and forth. I knew he was a joke when he made the Today Show comments. Right. That's what Bob and I said yesterday. Those Today Show comments, like, what are you doing?
Pandering. He was absolutely pandering.
Also, check your email, Jody says. Jody Phillips. Trace, help. Oh, on X. Check your email X, like your DMs on X. Well, I guess check both of
I'll
them.
check both. I'll check both.
And Edward Kilpatrick came back again. Thanks all of you for your generosity. Judge better keep this same energy for Tully's motion that contains an explicit lie about only supervising when he did interviews at all of everybody, of many. Yeah, we still have to get to that motion. So And then I Stand with Mel again says, did you hear the judge say actions that are nothing more than free publicity for the attorneys? Grouchy old man. And what's he doing? What's he doing? Again, I'm about to play that. I got a couple more comments. We're about to go back to it. Casually Kiki says, and thanks for your continued support. I love being a member of this community. We love having you. And Jen TO4 or Jenny says, Aiden has the same judge in the defamation case. Really?
Ian is saying there's an account that was noted as posting them, which is no longer active. I didn't hear that.
Did he text you this, or this is on?
No, he
X?
posted under my post. Like, I didn't hear any mention of an account.
He said
Other
an
than
account,
to say-
but he didn't say
That's
the.
all he said.
Wait, read Ian.
Ian said there is an account that was noted as posting them, which is no longer active.
No, right. He's not saying the judge said that. He's saying that that's what people have sniffed out. It sounds like.
Interesting.
Aiden, do tell. I mean, Ian, do tell more.
Yes.
Well, that's kind of scary, Jen. That if it's the same judge in the defamation case, that's a thing.
That's a thing for sure.
Wow, that'd be scary. And then Shelly, member for 16 months. Thanks for your continued support. I think he is the judge for the defo case too. So you guys are all letting me know he is the judge for the defamation case. So, and Lazy LCH says, I think he must be talking about Aiden's post. He said similar information was posted. Me too. I mean, what was it? What Edward said. I mean, somebody double check it, but it sounds like that's the most logical explanation here. For sure. For sure. Jody says, listen to the judge when he says we met at 8:45 and I said I would give my ruling by 4:15, but Grant Ellis Smith leaked this at 2:52, have sent you the link via email. This has cost me a fortune. Because Jody keeps sending money. So I don't know. Listen to the judge. He says we met at 8:45. Right. But what he leaked, as we've seen what he, I mean, Jody, I guess, babe, you got to pay attention to the regular chat. So
Babe, I was looking at the email.
Oh, sorry. Sent you I don't know if it's the same thing, but I thought we realized that.
All right, so
what Grant said is nothing.
Joe sent a link to a different breaking news. Michael Proctor. So it's 6/8/2026. I don't know what time. Let me see if I can see what time. At 8:43 a.m. So Grant had breaking news. Michael Proctor will be forced to appear for his deposition today with Alan Jackson and Karen Reed. However, judge will delay his final ruling until 4 p.m. Eastern Standard Time in order to supplement Proctor's insufficient arguments to the court. Another hearing will happen today at 4:15. The depth for now is stayed for 24 hours. More as I know it, and that's it.
Are we seeing times different? Are you
Yes,
seeing?
I think I'm seeing it
Right.
in Central Time.
In Central
That would have
Time.
been 9:43.
Right. Okay. And so everybody needs to be cautious of that. When you're looking at it, if you're not on the East Coast, you're seeing a different time on X than what we're talking about. So now and Lazy, we're about to listen to it again. If Lazy asks if the judge permanently stays discovery related to Proctor, does that mean they can't use what they got on the 25th? No, I don't think there's any way that the judge can prevent them from using what they got on the 25th. But if something, additional happens, he's saying that he'll just outright dismiss the whole damn case. So, but it's not, it's a case against Karen. So go ahead, dismiss it. I don't know, but we're going to go back and listen. And then I Stand With Me said, did you all read the response from Karen Reed's team about the depositions? They listed all the deposition reschedules. Julie Albert just didn't even show up, did not call, nothing. That's crazy. We'll get to it.
So Ian responded. So I said, do tell. He said, I just did. Some account that was created shortly before and then was no longer active when I saw it. So he clearly didn't remember
he
what it was
didn't think
because
so,
it was
right.
like, it was just something.
That's crazy. All right, so let's hear what the judge said one more time here.
Cases like this, where all parties involved are aware of the public attention, I expect that everyone is taking every precaution to preserve confidential information, to follow the rules of the court, and to adhere to my orders. Because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. If necessary, I am fully prepared to make such order permanent as permitted by Rules 26 and 30.
All right, so he's prepared to make the order permanent
As to Proctor's death.
As to Proctor's death. And that's where we got to all this additional discussion about how the lawyers are going to promise that they're not going to share it and they're not going to use it.
To any
Move
issues
the
counsel may raise as to the
PC
management
up
of
a bit.
discovery issues
Thank
being
you.
within my discretion, I invite you to look at the following cases.
All right, we can
In the
move past the
2030
cases.
2 discovery and evidentiary rulings, 87 case, the SJC of the judge. In Cronin versus Strayer, it stated that the timing of discovery is within their discretion for the authorization of protective orders. With this authority at hand, judges should not hesitate to exercise appropriate control over the discovery process. And finally, in the 1987 case of Campari Mass 7, a Ford discovery process operates efficiently. The malicious publication of private information concerns me. Whatever opinion that one may have of a non-party,
All right, we
even
heard
if
that.
warranted, all people deserve fair and equal treatment in our system of justice, regardless of any personal characteristic.
Really? Again, the irony. I mean, all people?
Like any
What
other
about
guy.
Black people? What about women?
Women,
What about
Jews.
Jews? What about Asians?
Yeah.
What about, I mean, let's just keep going. Anyone who's not a bald cop.
Right.
But I say that in jest, and I do agree with what this judge is saying. If there had been the malicious use of somebody's, private medical information, but there isn't.
As abhorrent as some of them may be, what I am looking for is for the parties is adequate assurances that their discovery served justice and not any desire to weaponize the rules for pettiness and profit. If the parties and lawyers would enter into an agreement to hold private, personal information in confidence, and if the terms were acceptable to me, I would consider entering it as an order of the court so that any violation would be grounds for a contempt finding and appropriate sanction.
So again, this is still tied with this first part of the sentence, is that Proctor, that he is prepared to stay Proctor's, discovery involving Proctor permanently. And then he's given but before I do that, I'm going to give y'all the chance to come up with an agreed order where you're promising that you're going to keep this stuff in private. And then I'm going to have this contempt tied to it. And if something happens, you're going to be held in contempt. That's option one.
Including dismissal or default. Such an order would need to be more.
So dismissal would be dismissing the case against Karen Reed, and default would be finding her guilty. I mean, liable. Finding an order against her, a default judgment against Karen Reed. I don't even know that he could do that, tell you the honest truth.
In a stipulation that deposition testimony can only be used for the purposes of this case. I encourage the attorneys to confer and to seek to reach an agreement. In the absence of an agreement.
And then his two, in the absence of an agreement that I like,
I will consider whether to enter in order based on my plenary authority to control, manage, and oversee the conduct of discovery. While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking. My final request to counsel with an appearance in this matter is to familiarize yourself with Rule 3.6 of the Rules of Professional Conduct relative to publicity, making statements that the lawyer knows or should know if proceeding.
I just want to see what he says at the
rule
end.
applies to lawyers who are or have been involved in the investigation or litigation of the case and their associates. As the comment to the rule notes, it is difficult to strike a balance between protecting the right to a fair trial and safeguarding the right of free expression. However, preserving the right to a fair trial for everyone necessarily entails some curtailment of information that may be disseminated prior to trial, especially where trial by jury is involved. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence. The rule takes into consideration that the public has a legitimate interest in the conduct of judicial proceedings,
Yes,
particularly in matters of general public concern.
as this is.
However, I'm not so sure that churning the waters to generate social media coverage necessarily can result in a legitimate interest in the conduct of judicial proceedings.
So who's he talking to, Bob?
I don't know.
The Reed camp.
I mean, it
All
seems
of
like
his
it.
comments are geared to, he thinks this is all the Reed camp. He thinks it's the Reed lawyers. He thinks it's Reed. He thinks it's Aiden. He thinks it's whoever. And it's not even, it doesn't even appear to be true. Is there something else this judge might have been relying on? Maybe, but at this point, and somebody needs to pay attention to like the regular chat, because I wonder if he figured out that, yeah, for sure, confirmed.
So
10
Larry Foreman posted, who was DUI guy. He had said, I love and trust my fans. A lot of you email me with tips, suggestions, compliments. This is an email I just got. I never heard from this person before, so that's already sus. Source, trust me, bro. Could be the McAlberts camp, could be legit. You decide. So he got this email from this individual, and it read as follows. Hi, Larry. Love your content. I have firsthand info that Proctor's estranged wife leaked his mental health info well before the info was given to the court. She shared it with her friends that shared it with their husbands. One of those husbands is my coworker that shared it with me. That info eventually got to Turtle Boy well before court ever heard of Proctor's motion to delay any deposition. So, because it seems clear.
Wait, so what time and day did he get that?
Let me see if this one has it. So this was June 8th, 1452. Oh, no, wait, that's
252.
No, that's Aiden's thing. Because Aiden's post, which we read, right? We read
No, not a 252 one.
No, yeah, 1450. It is that one based on what Fitzpatrick said to us.
No, I just checked it. So
all right, so this particular, I thought it was because I remember you saying the P word. So this is 1452, June 8th. Michael Proctor decided to have a mental health crisis after the whole world found out how racist he is. Sources tell us he checked himself into a mental health facility in Florida to try and avoid today's deposition. They filed a motion.
Wait, let me ask you, what are you looking at? What did she send? A picture?
No, this is under my post. Do you want me to just pull it up?
Yeah, because we saw the post. Aiden's post is 10:52 a.m. And that is never by any, unless I'm missing something. I just Googled it, is 10:52. Oh, wait, I did that wrong. Okay, is 2:52.
Law Girls Not Attorneys have an interesting little DM thing going. They're saying, and we have not covered Tully's motions yet. They said, dude, can you believe Tully's lawyer used robot lawyer? I'm dead. So we're clearly going to have to get the Tully's motion. Like if his lawyer used a robot.
Yes.
lawyer-
Sorry. Sorry. I'm really interested in that, but I need to correct myself. Patrick Fitz, what was his name?
Like it was Fitzpatrick.
Right.
He's
Edward
right in the
Fitzpatrick is correct. That 2:52 p.m. UTC time is 10:52 a.m. Eastern Daylight Time. So that's what everyone is getting confused. That's
Can
what.
I pull my?
Yeah.
Okay.
Make it bigger.
Oh, is that mine? Okay.
Yeah. So
All
that's
right. So
words she's speaking, or she connected
right.
the post.
So there's Runkle. So there's my post. Okay. I'm basically saying it's much ado about nothing. It was curious, blah, 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 blah. All right. So Runkle's like, there's an account that was noted as posting them, which is no longer active. Do tell. Runkle says, I just did. And then LGNA posted here. So they posted this. I could not read the full. Let's see. So that's 10:52 a.m., but deeper down, and it's the same post. So it's somebody was posting either to Larry. All right. So here you go. So Rich, this is where it is. So
And
in
does that
Rich's
say
post,
2:52?
I'm going to pull it up. Big as all get out for you.
Thanks.
14:52.
So that person must have their clock set to UTC time.
Well, that's military time. 14:52.
But it wasn't. His post was 10 a.m. So 14:52 is 2:52 p.m.
Right. UTC.
It's
Right.
gotta be. It's gotta be. So and that
So
must be
was
what the
Ian
judge got.
talking about. Like clearly this seems
Well,
to
maybe there was something else too where they put additional information. But this is definitely the answer, just as
right.
Just keep blanking on his name. Edward Kirkpatrick said,
Under his eye.
Yep.
Blessed be the fruit.
So when did the person send that to DUI guy? Was that today, just now?
Let's see. Larry's, I don't know. No, Larry's post was the one where he had the
Yeah, you were just at it. You were literally just at it above you.
Oh, I thought you were talking about this post.
Oh, sure. What is that one?
This is the one that I read where he had somebody emailing him that it was a leak from Proctor's wife.
And when did they send that?
I can't. No. This would have been a few days ago.
Well, it's right there. It says July 1st, 11.
They sent that, but I don't know when Larry's was. So Larry gets this July 1st, which was today. So I don't know if Larry posted this today.
He posted 2 hours ago. Yeah.
But I don't know if that's a screen grab from days ago. You know what I'm saying?
Oh, but it shows the thing he has attached is July 1st. So
right. Which is today. So yeah. Interesting stuff. I mean, look, this is all the shit that courts are going to have to deal with. And if you think it's going to get any better with AI, you're living in a dream world. This shit is going to be a kerfuckle. Like,
I'm sure
somebody up here was saying, look,
I'm sure AI now knows that it's his post that the judge is talking about.
Yeah.
And the judge is just wrong.
Well, see, and the problem is
it's somebody gave it to him in UTC time.
Well, yeah, but beyond that is that somebody said that he's the judge on the case against Aiden and Karen as well. He's the judge that's a problem. He's already up on all over Aiden.
You know what? They just have to realize, and when I say they, I mean older people, like
the boomers.
Yeah, that
boomers always take
information is not private anymore. Everyone can figure out where anyone is, and when you've got someone that big in the public eye, is going to tell someone else what's going on.
Yeah.
So, and I don't think that Aiden should not be allowed to report what he finds out. Right?
Wait, you think he should be able to report?
Yes, I think he should
Yes.
absolutely be able to say that his sources told him that he
Or-
checked into a mental hospital. I mean
Absolutely.
is that a HIPAA violation? I don't know.
I don't know. I mean, he's not the one. Like, I don't know. Is it?
I don't know. I think HIPAA only protects like the actual information from one to another, not
Yeah.
me just sharing what I know
Yeah.
about
Like in a
somebody.
world where that info is leaked and it's sent to somebody who is a reporter, and that reporter puts the information out, they didn't violate the HIPAA.
Right.
I mean, does HIPAA extend to everybody in the whole
As far
world?
as I know, it just extends to the records or information from the doctor to whoever.
So if
And
I
then
found if somebody dropped their medical records outside of the doctor's office and I pull up in the spot after them and I'm like, "Oh, well, gee, here's a whole
no,
bunch of medical records," and it turns out to be somebody of note, and then we jump on a live and
no, we have violated his right to privacy, and that's an independent
Well, okay,
lawsuit.
so what happens if I hand those documents without looking at them to somebody else, and then they tell me what was in the documents? Are we covered there?
I don't know.
I don't know. We're no HIPAA lawyers, so I'm not gonna pretend to know the answer to that because I don't know. It's worth digging into. Somebody ask the robot so it can fuck it all up and give us the wrong answer.
uh-huh.
Man, oh
I
man.
mean, the I don't think it's a HIPAA violation, but I still think it's actionable as uh, you know, it's when you air private facts about somebody that's, you know, a lawsuit. But that wouldn't not, it wouldn't be HIPAA. Um,
I mean, the thing that I want the judge to expand on is what is he considering private information?
exactly. That's what we said initially.
Right.
Because technically, if that's considered private information, Aiden violated a privacy tort, reporting publicizing truthful information of that's private, you know.
Well, is it still private if somebody who knew? Because look, I mean, if
But
you
I
work
think it's
this,
newsworthy here
it is
because it goes to
100%.
it goes to his mental health response to the publicity of his
It's 100%
improper.
newsworthy. There's no
Right.
question it's newsworthy. But let's walk it back. Okay, so we have, and the reason that I was talking about under the pains of perjury, that language last night is because lawyers are going to take that very seriously. I completely believe every single lawyer that filed their certification with the court today, or whenever it was, if it was late last night, that none of them leaked this information. I believe that with all my heart. Both sides,
And
lawyers aren't putting their
how you'd have to be a pretty stupid lawyer, which Alan Jackson is not, and neither of the lawyers that we know on the Reed side are not, to actually literally share that kind of information with Aiden. Just because the chances that he's not going to go public with it are slim to none. Like you would be like, fool me once, even if there was a fool me once, whatever. Like they took innocent communications and you know, made it into a thing. I'm not going to do something for real.
so what I want to do is walk it back though. So we're going to take the lawyers out of the equation as the potential leak, right? So then when you're thinking about it, who does that leave?
His wife.
His wife, maybe a stenographer, maybe
No, we're not talking about the deposition, right? Where you're crossing.
whenever the information became a thing. Because he
Right.
sat for the death. Like,
Right, but
what I don't
he sat for the death weeks later, and that's when he was seen having a breakdown outside of the
Okay, all
courthouse.
right,
So
so
we're talking about he's at a hospital in Florida
Right.
information.
So other
that-
than somebody close with him, who else would know?
or
Because
someone
at
close
that
from him
point in
told
time, the
someone
lawyers
close
wouldn't,
to
like
them.
you said, they don't even know because it's weeks prior.
Babe, you're
But
missing your
whatever.
timeline up.
But wait,
June
you're the one who just.
8th, they filed their
I'm talking about when he
motion.
was in the hospital. You
June
said that you
8th.
just said that he was weeks prior in the hospital.
No, I'm talking about the deposition was weeks later when he was being consoled out in public by his lawyer, where there's this whole panic attack thing. We're talking about going back to June 8th when Aiden makes that post before the lawyer's supplement and says he's at a mental hospital in Florida.
Okay, so clarify your time. Is that earlier in time?
It's days after they file their
So
motion.
after he leaves the DEP.
No, forget about the stupid DEP. The DEP has nothing to do
Okay.
with anything. That was
Right.
weeks later.
Okay.
So right after, so remember, Proctor's lawyer files this motion seeking to continue the deposition because of those 3 reasons that it said in the very first motion.
Which the judge said was insufficient.
Right. And then Aiden's post is between the break when the judge says, go, make this, give me more information to support what you're saying. And his post is long before they provide that.
So
But
this
again,
is when Proctor was thought to have been dodging.
right. Well, he was
the dodging.
possibly in the hospital. If Aiden's information was correct, or what the person that told DUI lawyer said was correct. So, but the post also said they filed their motion with an exhibit. Where'd it go? Let me pull it up. He said they filed a motion at the last minute on Friday to delay the DEP, but the judge wanted proof. Now, Aiden already knows this because the hearing we all watched. They submitted an affidavit that was impounded because it likely said Proctor was in a mental hospital. So that brings you back to what was the first
leak.
Right. What was
and it was long before anything that was filed in that motion.
No, what was the first
judges.
motion? So when you look at their first motion, and I'll pull it up and I'll share it. Oh, we were still not done with rehearing what the judge said at the end, so I'll have
We'll
to
bring it back up.
go back to that, right. So
All right, so you're right, babe. It's not a HIPAA violation. Nina Hartz came in. Thank you very much. It's not a HIPAA violation unless it's the provider / staff breaking confidentiality. And D Nice seconded that. Thank you very much, D Nice. The only way it can be a HIPAA violation is if somebody from within the hospital gives out the content.
right, or a person that got it from the hospital and has said you're not allowed to share it because
US Lily 80 says, please look at Turtle Boys live June 6th. You got a timestamp? I can't watch all of Turtle Boys lives. They was it answering a turtle chat? you got to give me an idea where it's at in there.
So I don't see the word affidavit but maybe they said it in the June 8th hearing. Wait, am I looking at the wrong thing? Proctor will be produced, but previously, oh, right. Okay. So it's not in here, but I'm forgetting. It is here. All right. I got it. How do I stop sharing? I got to share this tab instead. I forgot about this. So then this happens. Watch, it's going to blank off. So after they file their motion on June 5th, all right,
here, yeah,
the judge says a hearing will be held at 8:45. Moving party to provide information concerning when counsel learned of it, and supporting witnesses' unavailability as referenced in the last paragraph of page 3 of the motion. This may be filed marked provisionally impounded with a supporting motion if warranted. So this says right here, right?
So
Now,
that filed when? June 5th?
that's the judge's order on June 5th after Michael Proctor files his emergency motion.
Okay.
Then on June 8th, before the hearing, right?
Mhm.
Other interested party, Michael Proctor's motion to impound affidavits and supporting material.
Which
So
is the
now
one we got way later.
right. So now let's go back to Aiden's post, which mentions the affidavit. And can I not share?
See, what the judge needed to do for clarity's sake, because we had multiple motions that were filed, including supplemental motions that the judge was requiring, is which motion he was alleging had been leaked or the
This
information.
one,
Which
babe. So
motion.
I'm going to go through it right now. So
Okay.
now that we just heard, then at 8:45 there's a hearing. Okay. Then
What
between
dates? Give me dates,
this is
please.
all June 8th. All
Okay.
June 8th.
All right.
Okay. Then after the hearing, it says that where's the one that says we're going to come back at 4? Okay. So he says, after hearing and having balanced the rights of the parties and the non-party deponent based on the particular facts of this case and taking into account all the other factors he's impounding, he found good cause, privacy interests involved, good cause to impound. So the order of impoundment is going to stay for 30 years. The affidavit attached to this motion. Okay. So that's how Aiden already knows before 4 o'clock, before, whatever, that there was an affidavit that was filed with the Friday's motion. So with the motion that got us here, but technically it was filed on the 8th, but before it was probably submitted like on the 7th or who knows, over the weekend. All right. So then they come back, right? They're supposed to come back at 4:15, right? So during that break right there, is when Proctor's lawyer is filing additional supplement right here. So, and we read this one yesterday. Okay. We read Michael Proctor's motion to provisionally impound additional material. And this is when the judge is saying 30 minutes after this is when the post came.
So
Oh,
which
Lord.
which day? That's again June 8th.
All
Still.
June 8th.
Okay.
Now I just got booted out.
Oh
So
no.
just takes a second. I'm good.
Yeah, we read that. We read that. Don't be hating.
Why is it frozen?
Everybody's trying to figure it out. Maybe the site's getting flooded.
Maybe. Okay. All right. So close your eyes while I scroll. Oh, not yet. Scroll down to June 8th again. So that explains that Aiden's text has nothing to do with anything that was filed at 2 o'clock. Okay. He's talking about the affidavits, the other affidavits that were already impounded. And the judge mentioned judge read this, out loud. Oh no, not this one. Sorry. The judge read this one, okay, which is basically the same thing, going to the earlier affidavit that Proctor's team had filed tied to the June 5th motion, okay? So then the judge says come back at 4:15, then they file this, okay? And it says 2:22 p.m. This is what Grant Smith put up. So those are the affidavits. Grant Smith is talking about just what it says right here, right there, that it was one from his lawyer and Exhibit B was medical documentation. So that's that. And then, oh, damn it, I stopped sharing instead of change tab share. Oy vey. All right, put that up, babe.
What? This?
Yeah. So then they come back. All right. He files this, then they come back at 4:15. All right. So all of that happened June 8th. So again, Aiden's text at 10:52 a.m. didn't have any other information than what was available. All right, we're gonna play. I mean, I don't think Aiden's gonna care, but I guess.
No,
Wait,
he
she
won't
says
care.
it's short. That says 4 hours.
That's what I mean. We need a timestamp.
Wait, Tracy sends it, and she says it's short.
You're muted. You somehow muted yourself.
Oh. No, that okay, wait, hold on. I didn't mute myself.
Well, your mouth was moving. We couldn't hear. I couldn't hear you.
You unmuted me?
I didn't touch anything.
Oh, so Tracy just sent me this episode, Aiden episode. Can you play this video, please? And thank you. It's short, but it's 4 hours. So
Okay.
I don't know.
Just drop out and support Adam Deitch. Because there's only two.
Unless it's like something like this, meeting with Bradle, Proctor and Good Ideology, Proctor and Turtle Boy case. Yeah, no, this is definitely not a short Proctor. Just the tip. I mean,
and she gets the, she's cool. I'm in a blue family and she has the blue thin line on her car. And when she gets pulled over, she doesn't get ticketed.
All right. I can't, guys, unless somebody tells me where to go.
Does anybody know in chat, like where in the thing? It's 4 hours. That's what I'm saying.
Okay. It starts at 3:57. All right.
Beautiful.
Okay, Trace, I'll try. If this is what the people want. What'd she say? Three what, babe? 3:57?
Did she text it to us?
Yeah.
3:57, yes.
Okay. Did I already pass it? Wait, now she says 150. It's something different. 154.
44.
$154. So, first fact that is wrong. Alan Jackson didn't fly in for that. Oh, for the deposition, maybe. But I don't think so. Because he wasn't there. What's the date?
What are you doing?
Where does it say the date?
Wait, where does what say the date? Are you wondering if this is the wrong?
No, I'm just wondering what date this aired. Like, where does it say on YouTube? I don't understand how YouTube works. But this is right what we wanted. So here we go.
Okay. What are you doing?
What are you
Play it.
talking about?
It's not playing for us.
Bob, you took this long to say it's not playing for you?
I mean,
Move it up there.
it is up there. It's not playing.
What are you talking about?
It's just sitting there with Aiden like making that
So
face.
for
right
how
there.
long though? I've been playing this.
Yeah, it hasn't played at all. So go right back to the beginning.
The info is pretty solid.
Oh my God.
What
were you doing?
Other things. I can't help that you don't use two screens.
I don't know if this is true or not. So I'm just reporting this as a tip. Not necessarily 1,000% confirmed at all. It's 0% confirmed, but I'm just going to read it. Because when a tip has like slightly more juice than like a completely made up shit, this one seems to have slightly more juice. All right. I got credible info from my coworker. He spoke to Proctor's wife, and he is in a psychiatric hospital in Florida for treatment. He wasn't.
So I just want to say because I played it already once. He says, hot take. I just got this in my inbox. Okay. So, and now he's reading it.
McLean's in Belmont, but left for Florida. And now he's being treated down there. I know from past comments from my coworker, just learned about the hospitalization a couple days ago. His wife and him are absolutely done. That's confirmed. She has separated herself from him for obvious reasons. So again, this is unconfirmed. And they go on to say, he's not sure how long this has been going on for with the ex-wife in the exact time, but it's been at least 2 months because the previous comments from my coworker about him being separated from his wife and in Florida were around 2 months ago. The coworker's wife is one of the best friends with Elizabeth Proctor. So the info is pretty solid. This kid that tells us this stuff only gives us info once in a while. It's not everyday conversation, unfortunately. He does have sympathy for Proctor, which I do not. And then Laura responds and goes, they might think differently now after the latest filing. And the source says, yeah, he's definitely changed his defense of Proctor from the beginning to now. Before, he was adamant that Karen was guilty and Proctor did no wrong. Now he has very little to say about Proctor's conduct. Tell Aiden all of us appreciate what he has done and is doing for civil rights. I place him at the top of that moment in American history. Well, thank you very much. So again, unconfirmed, but sources are saying he's doing the rehab thing to try to get out of this. He might be in Florida. I don't know. But to me, that would make sense. I would go to Florida. Dude, what's he going to do? What's he going to do, that guy? He's going to lose everything. His wife stuck by him because it's her goal in life to be married to a cop.
All right. So there you go. But I don't know when the date and time of this. I don't understand how you can
Hold on,
tell.
I'm going to figure it out.
Like where does it tell you these things?
I'm going to figure it out.
That's why I'm always like, hey, say the date and time when you do a live, because I don't get it. Or the date. So, all right. It sounds like Aiden got information from someone who got it from someone who got it from someone. Tracy says June 6th. So this is after the filing.
So here's my problem then. And like, this is why you need the judge to clarify if it's June 6th, what has been filed at that point? You said there was a filing on June 5th, right?
June 6th, but June 5th is the motion.
And with that, there was an affidavit?
No, with that, then the judge said, asked for a little more then. Okay, I'm going to put this back up one more time. So they file their motion, right? Motion for protective order. The judge says, I need more information, especially supporting the unavailability as referenced in the last paragraph of page 3. That was the one. I'll just pull it up. Why is this frozen?
You want me to put this up?
No, it looks like maybe it says like down here, the judge, June 5th hearing to be held. So Scout's calling. Well, maybe I opened the wrong thing. Okay, sorry, I did. I opened the order thing. All right, share this tab and said, is it up, babe? Babe.
It is.
Okay. So, second, due to personal circumstances, Mr. Proctor has also been unavailable for deposition preparation. The undersigned only became aware of those circumstances recently. Counsel for Mr. Proctor will, if the court so desires, provide additional information to the court regarding Mr. Proctor's personal circumstances and need to reschedule. So, and then he made that footnote that last time we released information or information was released, it went right out, somebody right afterwards, it was public. Okay. So then we go back over here. The judge says, give me more on that paragraph, right? Then they file other additional affidavits and supporting material under impound. That
All
is
right, so pause it right there.
Yes.
So Aiden's got this information on here's my thing. So when the judge doesn't come out and specifically say what he's referring to in terms of this X account, and it's 2 days after Aiden's live, why is he flame throwing lawyers as if this was information that came out?
How does he know about Aiden's live? How does
But
anybody know about Aiden?
That's not my point. The information was out. We just heard Aiden say it. And that was 2 days before the 8th. It was on the 6th. Why is he turning around, he being the judge, and making it as if when we know that it exists in the world because we just heard Aiden say it. Why is he putting it on the lawyers as if they potentially disclose something?
Because nobody knows that Aiden got that inbox on June 6th, except the people who were watching Aiden's live.
And maybe he should have let the lawyers talk.
Right.
Because
Exactly.
He's got the wrong impression of what happened here.
Right. We know that for sure now. That
right.
Thanks to
That's in stone. That's
Edward
in stone.
Kirkpatrick's UTC time, that thing that you put up with that somebody emailed you, that's showing that people are out there sharing that post with the UTC time, making it appear as though it happened at 14:52, or maybe that person is just in a different time zone.
But the point being that Aiden disclosed the information first on the 6th, 2 days before that post, right?
I know, but I don't know that anybody
getting confused.
But I don't know that anybody knows it. Do you think the lawyers are sitting around? I mean, now they'll know it.
Yes, I think everybody is monitoring Turtle Boy's YouTube channel. Yes, I do. I absolutely do. Well, do I think that the judge was? Obviously not. Because if he knew, he would have said, oh, well, this guy found this shit out 2 days earlier, so I'm certainly not going to call for every lawyer under the pains of perjury and pains and penalties of perjury to send me a certification that they're not the ones who leaked it, because it was before the shit was even filed that Aiden knew it.
Right.
Like that's where this is bullshit.
Right. But when he reads Aiden's post, which again says, let me see. Oh, gosh. Why can't I? All right, I'll just pull it up from here again. Which again says, sources have told us he checked into the hospital, to avoid today's deposition. They filed a motion last minute on Friday to delay the depo, but the judge wanted proof. They submitted an affidavit that was impounded because it likely said Proctor was in a mental hospital, which we know how he already knew this, right?
Right.
And then, but the judge is like, oh, an affidavit saying he was in a mental hospital? Well, shit, that's exactly what happened 30 minutes before he thinks that this thing came out, and that is what the affidavit said. So Karen Reed's lawyer made the mistake of saying the scheduling of a deposition was strategic, which the judge took issue with based on his comments, on the Today Show. He stayed the dep for 24 hours and at a 4:15 hearing, and a 4:15 hearing will be held. So the judge is thinking all of this is happening between that, and I think that that's the end of the day. That's what all this is. That's what all this is about. That somebody had the wrong.
Yeah.
That time. I mean, we've got it. We've got it. And I'm assuming that Alan Jackson's going to make all of this clear to the judge.
Yeah.
All right. So now let's pick up. Is this showing on your screen?
Yes.
Okay.
Read the rule, especially if you have never done so. I remind counsel of what consequences for failing to do so. I remind counsel of what one commentator called
Oh gosh.
quiet expectation.
Yeah, we
of
get
the
it.
Founders of our country.
The
built.
quiet
Counsel,
expectation.
do your part to maintain the quiet expectation of fairness. Do not succumb to the attraction of seeking to influence this case through social media. Be what a trial lawyer should be, one that tries their case in the courtroom. And remember the provisions of General Laws, Chapter 221, Section 28, relative to the oath of office for an attorney in Massachusetts, which provides, in part, I solemnly swear that I will do no falsehood. I will delay no man for lucre or malice, but I will conduct myself in the office of an attorney within the courts according to the best of my knowledge and discretion, and with all good fidelity, as well to the courts as my clients. So help me God.
Man, the judge is gonna have such egg on his face.
All the egg.
Such egg on his face. Oh Lord, let's just see. Let's just remind us what he said at the end.
I wish all of you a happy 4th of July on the anniversary of our America's 250-year-old democracy. May it continue to succeed with all of us working to maintain the rule of law. Thank you.
Court, all right.
To compel the criminal fourth session.
To be heard? There obviously no opportunity to be heard.
I was unaware. I'm just covering for record benefit today.
Is there an opportunity before anybody departs to let the judge know that we would like to be heard?
Absolutely.
And then that was that.
You will say nothing and like it.
And they came back for like a hot second. This is when we were like, oh, I was like, oh, it's alive again. Like they thought, all right, maybe something's gonna happen. And then it went out again, and that was the end. So,
Did you send Scout money? I am now. I'm just making sure you didn't.
no, I did not. I
Okay.
did not. So, I mean, let's see what you guys are saying. And thank you, Uncle Frito. U.S.
I mean,
Lily
the
8,
case was just cracked right there.
right? U.S. Lily 80, thank you. And now we have looked at Turtle Boys live June 6th, 2026. Oh, and you read these?
Yeah.
Okay.
Yeah, that was it. That was the secret sauce. The
So
June
Jody
6th
said the link I sent was UK time. Recheck your email.
Okay.
So, and that maybe UK time is the same.
But either way, that post on June 8th means nothing to me now.
Well, right.
We
It's
were
just,
given the heads up that Aiden knew this back on the 6th.
but it just explains why the judge thought his post was at 2:52.
But that's on the judge for
Right.
not allowing the attorneys
Egg
to speak.
on his face.
Yeah, I mean,
Like
that's
giant egg on his face. Like you have to like.
so all that shit that I was saying, really degrading the attorneys in the room. I was just kidding.
He better come back out and apologize.
I mean, he's gonna have to.
He's gonna say, look, the
Well,
thing
the
is,
fact still remains. I want
Right.
you guys to play nice. It's like I
Right.
may have been mistaken there a little bit because I didn't let you guys speak to me after I read you the riot act about not being shitbag attorneys and being unethical.
or
So,
just, or just he could have sent them the post and said, be prepared to explain this.
yeah.
Put this in your certification. He's
Yeah.
keeping it under his little whatever.
All right, so we just got an influx of people. You guys are probably jumping around. Allie basically just cracked the case.
I mean,
with the help of our
chat.
chat, obviously. So what happened here? It's pretty simple. Aiden gets it seems to be the same leak that Larry Foreman got on the 6th. Aiden then goes live, puts it out there, the Proctor News.
That
2
the wife
days.
said that he's,
Right.
2
days
somebody found out from the
prior
wife.
to anything being filed in terms of an affidavit in the case. The judge clearly not aware that Aiden had become aware through some source, not knowing. A was very clear. He's like, I can't vet this. As far as I know, it's a
And
rumor. It could be true.
And he didn't post
qualified
it, by the way. He didn't post it until after that first part
Exactly.
of the hearing on June 8th when he's like, all right, well, everything they just said supports what this person told me that he's in a mental institute in Florida.
Exactly. So that comes out on the 6th, out of his mouth on a live on his channel. 2 days later, the affidavit is filed. This unfortunate for the judge, unfortunately timed text or X post hits the waves. Somebody alerts the judge that this thing took place. The judge is like, "God, I can't believe it!" You know, like he's furious in his chambers. He's like, "Oh, he's screaming and yelling, like, these lawyers, what's going on?" So he fires out, you know, his order saying that under the pains and penalties of perjury, everybody's going to need to give me a certification as to whether or not you leaked this information, all without knowing that it was out 2 days prior. And because he wouldn't
all
allow
without knowing, no more, all without knowing that the time was not 2:52 p.m., but instead 10:52 a.m. Eastern Daylight Time.
Right. That would have helped him for context clues. He's like,
Yeah.
well, the thing wasn't even filed then, so it couldn't have been that. Yeah, that's like
That's the biggest thing.
The
Is that
biggest thing is he
somebody,
didn't
some
allow the
idiot
attorney.
out there, some asshole out there getting all worked up with looking at the wrong shit, thinking they sniffed some shit out.
Yeah.
Oh, it was a 1452. That's 252. How the
Yeah.
hell did he know?
Smells like the forensic 4. Jumping the gun. You guys do the work. Who's the first one who started whining about that particular message? Because that's the $1 million question. But that's exactly what went down. I fully anticipate, as Allison said, either one of Karen's attorneys is going to draft up exactly how this shit went down. And frankly, the judge owes these attorneys an apology for maligning their integrity, because that is not what happened. It's very clear. Whether it was clearly it was accurate. The one thing that we know at this point is whatever intel that Aiden got, and maybe Larry Foreman, because it appears to be the same person, because we're talking about co-workers.
But
And
Larry just got it today.
Oh
babe.
yeah, right. So Aiden got it way
But
before.
the point is that Larry got the wrong time. He got the one that says 1452.
Right.
Literally on the post.
Right.
By meaning that the person who sent it to him either has their computer set to UTC time, or I think someone said, Jody said, that's UK time.
Right. So ultimately, what's going to go down here is one
Someone
of
in the
Karen's
UK said it.
attorneys is going to write a nice little motion / memo, something that's going to go out and get filed, and it's going to put the judge clear in terms of the actual timeline of events. And the judge is going to be forced to recognize the fact, oops, I jumped the gun. I jumped the gun a little bit here.
And if I would have just told him what I had, maybe I could have let them explain it to me. Or if I would have let the lawyers talk who came from California.
Yeah.
For God's sakes. And Classic Overthinker gave us the time. It was 1:52.
Yeah. I mean, you know, in life, sometimes you need to be knocked down a peg.
Yeah.
You know, maybe he'll relax a little bit, you know, but like all the things that he's saying, he's still going to lean into it. He's like,
he was waiting. He's been waiting. He watched that Today Show, and he keeps perceiving things through his, you can tell how jaded and slanted he is towards the Karen Reed team, because he keeps perceiving things the way he wants to. You know, he can take a second beat to be like, wait a minute, there was also an affidavit filed before, you know, the first one that was impounded. I got 2 impoundment orders out here. He's talking about, we're still coming back on the 4 at 4:15. And do you also think that he had a spy inside your brain to know you were about to order Proctor to come the following day? Because the judge did. He's like, he's coming tomorrow. Tomorrow he's coming. And then the lawyer's like, oh, wait a minute.
Here's the thing. And you know what? Like, ultimately, at the end of the day, the judge is going to have to sit there and and like own the fact that he made this mistake.
He has to.
He has to, because he really was maligning. And I agree. He was clearly speaking to Karen's attorneys, had them as the dirt bags that were spilling state secrets. And, that just wasn't the case. It wasn't the case at all. And, how he's going to respond to that will be interesting. But at the end of the day, like I said, sometimes getting knocked down a peg isn't the worst thing in the world.
Right.
'Cause
And also,
he's running hot. Like
if you're listening, Judge, going to get mental health treatment is not a horrible, horrible thing that is so needs such protection and privacy that the world can't simply talk about the fact that the man, and maybe it is drug abuse, who knows? It might not be like strict mental health. He's like, I got to explain this. I was on drugs. I don't even remember saying that stuff. What did I say? I'm not a racist.
Oh, you mean for decades?
For decades.
It was
That's
like
true.
10 years
That's
of
true.
shit, man.
That's true. I've been on crack
walking that shit
for
back.
decades.
Yeah, my rant last night stands.
But no, and I hope he doesn't pull a Judge Canoni, and that he recognizes when he makes a mistake and he says it, and he talks about how he has no reason to believe that all of the lawyers before him are not of the highest caliber, blah, 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 blah.
Yeah.
So Julie Jensen says, what would Judge G do if Alan Jackson stood up and said, Your Honor, I need to go to the bathroom?
Yeah.
If
and
you
like
know,
I stand with
you know.
Mel, like she said this an hour ago. It's like Bob was talking about the language that the judge used in the motion. Yeah, we're talking about the pains and penalties of perjury. Serious business for a lawyer. Like your sphincter tightens when you got to judge it, even if and obviously all of Karen's attorneys knew they didn't leak shit. So they're like, I don't even know what this guy's talking about. So then obviously I'm assuming it would have been smart for somebody to call Aiden for one of the lawyers and be like, yo, well,
he didn't know. Clearly he didn't put it together, because the first post you put was Aiden saying the only one at 252 was Grant Ellis Smith, and he just reported the public document. So at that time he hadn't put together that this was all about a mistimed somebody in another country looking at their time and screenshotting it and sending it to someone on the East Coast. So it looks like his post was I'm sure he knows now.
It was probably one of those Australians. There's a group of Australians that just hate Aiden. So it's like, who knows see, I mean, this is where kind of like having some background in the drama is helpful, because of the fact that social media exists in this world. And, but like, here's the thing is that what the judge is failing to understand is that there are so many people so entrenched in this case that they know everything forward and backwards.
Right.
And that this shit is going to get sniffed out online like it did in real time right here immediately, because people just know this case forward and backward. And there's people that know the facts of the cases forward and backward, and who know the drama forward and backward. So they're schooled in both areas. And, I mean, this is what you're going to end up getting is a judge who, as you say, is going to have some egg on his face. He'll go up there in his robe, huffing and puffing, and well, I can't wait to hear it.
Well, it should actually make him hopefully have a little bit of a wake-up call to say, all right, I have been perceiving everything through a lens that now I'm realizing is wrong. And I've got to recalibrate my lens so that every time I see something, every time I hear a word like Aiden put in his post that the lawyer used the wrong word, strategic. We said it yesterday. The judge hopped all over it. Oh yeah, strategic. Like the filing of that complaint that Karen Reed said on the Today Show she was always going to file just days before his deposition as a what? The guy already knew that shit was out there. He has had it. We just saw him warning Good in 2025 like, yo, dude, they got your shit too.
Yeah.
And then Good goes to his boss and is like, so here's the thing. They got some text. I don't know what's in it, but you know,
I don't see it as a sadly. I see it as a community effort. We love the fact that we can rely on our chat to tell us what's up. But we cover a lot of shit. There's no way we're not specifically and only Karen Reed stuff. We cover a lot of stuff. So
I mean, I'll
we
tell
rely
you,
on you guys to tell us what's up.
and I'll
we
tell you,
listen.
yesterday, going through all the docket and all the stuff to just prepare for yesterday's live, I was like, this is a whole other, like, that's a lot. That's why Bob and I had initially said we will cover it when the motions for summary judgment come. But then there's just been obviously too much stuff that warrants and requires.
Everybody's screaming in the chat. Keep chat keeps telling you guys.
We know you do. We know you do.
Like, we're trying to work back here and do all this stuff.
All right. So Edward Kirkpatrick, who really is the one who bust this thing wide open, says there needs to be an evidentiary hearing now. Strategically, also gets this judge off the case. What did the judge learn and from whom? I mean, yeah, good question. And why did you not take the time? And that's what he has to ask himself. Why did you not take the time to look at it from different angles and jump right to the conclusion that you jumped to? I mean, yeah, the time made it seem like that, but that's why Edward's question is right. Who'd you get it from? Because he didn't get it from looking at his own ex. Because if he had looked at his own ex, or someone in Boston had looked at their own ex, they would have seen it was 10:52 a.m. So he didn't even go and like have somebody check it themselves to be like, can you see what else was being said? Because then they would have seen that the time wasn't the time that they had. But thank you, Edward, because you cracked the case wide open.
The chat was screaming at us. They're like, you idiots, look at the shit. They were basically yelling at me. Like, I think it started with what date Aiden's thing was, and the chat was screaming at us. It was the 6th. It was the 6th. And then, like the whole thing. So they had it figured out before we did. So,
yeah, that's for damn sure.
Oh,
all right. I'm the problem. It's me. Thank you. Apparently, Maddie did the same tactic and got default in Jones' case. Sheer admiration for the Sean Ellis interview. Love you both from Ireland.
Appreciate
Italy.
that.
What's that? Italy?
It's too small. It looks like Italia.
Italia.
We
love Italia.
It could be. Wait, is that the?
Yeah, that's the Italian flag.
I mean, let me see. Hold on. I just
better just check the chat. I mean,
it's the Mexican flag, but that has a seal in the middle of it. So, but I don't know. Let's see the Italian flag.
It's Ireland. It's Ireland.
What? It's so.
And then someone says no, France.
What? I can't tell if it's blue or green. France is blue. That looks green to me.
It's Ireland. Shit. So that's what I said first. Ireland.
Wait, Ireland. Hold on a second here. There is no way in hell.
Here you go. Ireland. CLK Staffy.
Wait, that's orange. Is that orange? I cannot. That thing is so teeny. There is no way.
It's orange.
Oh, yeah. It's Ireland.
That's what I said at first. Okay. Back on track.
I derive no more.
We're probably the only ones that learned anything over this. Everybody else already was like, we're just
no one knew until after the hearing today. Because I hadn't seen anybody say anything about Aiden's poster because we couldn't know. But somebody should have put that together. Like, how didn't Aiden say?
Aiden didn't even put it together, right?
What I mean, I said this shit on the 6th. Like, what is this guy talking about with shit on the 8th? Like, why is he putting?
Yeah, but once the judge says 252, Aiden's like, not me. Okay. Even though he didn't have anything to sweat about, but it wasn't even. He's thinking, all right, it's not even talking about my post,
right?
But now he is talking about your post, right. But he's got it all wrong. Exactly. Hence the egg on the face. All right. Roosevelt Media News says, I am sure it was just a coincidence that the information about Proctor's mental illness was leaked by his wife because recuse this judge for his bull butter. I mean, I'm being serious when I say I really do hope. Like, first of all, I would like to know if the judge, I should have stayed on and listened to the way he talked in every other case that was before him today to see if he has like a pre-written and partially memorized, because he doesn't look down all that much at the papers when he's reading them.
The papers.
You know, and if he makes like if he's quoting lofty, you know, shit and saying all these things to everyone, or if it's just here. Because again, we've all said it and everyone's saying it. He's the one that's pandering.
Uh-oh. So I'm the problem. It's me. Melanie got a document that the judge and Brian Albert have a civil case. They're both defendants. What?
Wait, what?
Outrageous. What?
The
Tell us
judge
more.
and Brian Albert are defendants.
Tell us more.
Wait, that can't be. I mean, I guess it could be, but that
it could be.
Like that would be. I'm conflicted out. We are parties to the same lawsuit.
Shaw.
You know, like, how could that happen?
That doesn't make
something doesn't sound right.
Something's. I mean, Mel got a paper, a document. Like what kind of document? We need more.
Right, because that doesn't work that way. But you know, it's Massachusetts at this point. Who fucking knows?
Oh, here. So Charles said, in all fairness, Bob, you were an irritating ass last night. Still love you, but maybe a half Red Bull is enough.
Right.
Fair. I mean, let's all not pretend. And I love my wife more than anything on the planet. She interrupts me constantly. That's facts. And like I have every single YouTube live that ever existed to prove that. So, you know, on the rare occasion, because I'm usually pretty good about waiting my turn, Allie's a little more impetuous. She likes to, you know, she gets it out there. So, I mean, it was a little bit of tit for tat, but you know what? I'll take it. I'll own it. Babe, I'm so sorry.
No, it wasn't all that. It was just like you were on one.
Oh, were you arguing? I'm like, yeah, we went and watched reruns of
we snuggled. Like I didn't talk about that live even
At
for
all.
a minute and we got off.
Yeah, I think we kissed and said that was a good one.
Right.
I think that's exactly what we did.
I might have said you're on one, but
you might have said, well, you said I was on one
on the live, so I don't know.
Yeah.
It's just Teeter I have sent. It's not just Teeter I have sent. Did she send something else?
Jody,
Jody Phillips is right in there in the busting this thing wide open too. Jody and
okay, so
Patrick.
She did. She said this might make better sense. She sent this at 4:01, so now we've already figured it out. So she's spelling it out for us. So here's proof positive that Jody at 4:01 had the whole damn thing figured out, probably along with all the rest of
everybody in the chat.
She said this might make better sense. The X post you're remembering was likely this one. Michael Proctor will be forced to appear for his deposition today. However, a judge will delay his final ruling. That post went out during the live hearing updates and discussed the medical information issue surrounding Proctor's request for a protective order. One of the interesting developments before today's hearing was that Grant Smith Ellis reported that the judge had canceled a separate scheduled discovery hearing involving MSP, so the court could instead focus on the alleged leak of the impounded medical information. That is interesting. So that was
so he's not taking up real shit because he's worried about wrong information he got.
Hammering the lawyers. Yeah.
Ay. Thank you, Jody.
Thank you.
Date Night Disaster member for 9 months. Thank you for your continued support.
I had no idea me when I'm looking through my emails or scrolling through the X, you know, it's like Bob's not paying attention. Well, I mean, I'm doing other shit. I'm not playing Candy Crush. I'll promise you that.
All right.
Whatever I'm doing is related to what we're talking about.
Okay. So Date Night Disaster says member for 9 months. I had no idea Becky Hill got a new job with Gildia. That's a good one. That's a good one.
A good one.
Just a girl from the 6. getting here late, but this judge is in a lawsuit with Brian Albert
What?
and Judge Krupp, amongst others. This, please, Bob,
He is
go through
conflicted
the
out.
chats. I'm looking this up. You keep going.
Call
All
Melanie.
right, what is his name? No, she's probably on live. Judge, what's his name?
Gildea. I don't know how he pronounces it. Gildea.
What's his first name?
I don't know.
Check the
What's his
chat,
first
they know.
name, y'all? Chat. You guys are our encyclopedia
Mark.
of
Okay.
all things, Karen. Reed.
MARK lawsuit with Brian Albert. Wait, is Brian Albert not a party?
Wait, they clearly said Brian Albert was a party.
Yeah, okay.
Yeah.
I
mean, that's conflict immediately, right?
I just have to ask AI because the Google machine's not doing it.
Oh, the Google. Oh, wait, Corey just. All right. Am I allowed to look at my X? Thought you guys yelling at me that I'm not paying attention. All right. I'm doing it anyway. All right. So let's see. Judge Carroll said today's hearing regarding alleged leaks in the O'Keefe Reed case left me with more questions than answers. If the purpose was to identify the source of the leaked information, it is difficult to see just how that objective was advanced when the attorneys were called into court but not permitted to respond or be heard. Courts have every right and an obligation to protect the integrity of judicial proceedings, but effective investigations typically gather facts, hear from witnesses, and create a record rather than holding a hearing to issue a public reprimand, which risks creating a spectacle. As a former judge, I would have preferred to see a process focused on discovering what had happened rather than a proceeding that appeared to uncover no new information. The ultimate question is simple. What facts did the court learn today that it did not know yesterday? Thank you, Judge Carroll. Exactly. All right, so here, let's see. Okay. Wait, where's Corey's post? Okay.
I can't find anything. So one of you guys in chat will have to. I mean, I'm sure Melanie's live, or I could text her. The search won't catch every docket. If you want to run grounds, mass courts, e-services.
I gotta go to Corey's.
I'll try it.
I'm not seeing the tag.
I'm gonna try it on the mass courts, but I don't know what. I wouldn't know what county to search.
All right, there's Corey, who just started following me, which was surprising to me a little bit. All right, and I'm following her back because she's lovely. All right, let's see.
Bob, I just
What? Who? What?
You obviously have seen that.
Oh, I tagged you on a post from Corey Hopkins. Okay. So Corey said, guys, 36 minutes ago, guys, I am 99% sure that the judge mixed up document 112, not available to the public, the subject of the court docs on this hearing, with doc 116 filed publicly at 222 and posted at 252, still available right now this whole time. It tracks. And the judge had no idea that this information was out in the world.
Oh, people are still getting it wrong. That's not right. That we now know he did. He is. It is the timing of Aiden's post. It is the timing of Aiden's post. It is Aiden's 10:52 a.m. post that he thinks came out at 2:52.
Huh.
And doesn't realize that
I'm going with my wife. No.
Edward Kilpatrick and Jody Phillips have cracked it wide open. We got this.
They said check the last 10 minutes of Melanie Little's live a few minutes ago regarding the
text. Melanie, is this real?
It says it's true. Melanie does have it.
I mean, I gotta believe him.
I do listen to DB. Oh, LGNA just emailed it to us. Let's see. I'm assuming that's what was emailed. Okay. Oh. All right. Okay, let's see. All right, it's 2484 CV.
Oh, hold on. What county? What county? Because I'm in here. I was just going to do a check.
Hold on, I can't. Kevin Hayden. Okay, hold on. I can't tell what county is this? It's not showing me the county. It's a screenshot. Superior Court, Suffolk County.
Okay, I'm in here, but it seems like everybody is like up in this thing. I can't get it to.
All right, hold on. I'll pull it up.
No, I'm already in here.
Oh, you don't want me to just pull up with?
Do you have it? Are you in the
Yeah.
Massachusetts? Oh, okay.
Law Girl sent it to us.
Oh, I thought you were looking for it in the trial court access.
Am I still in here?
Your screen? Now it is.
Okay, hold on.
Oh, God. Stupid thing is like due to maintenance, downtime, or capacity problems.
See, it's a good thing. It's a good thing. All right, let me pull this thing up here once I open it up. It's some kind of interesting looking thing, I'll tell you that.
Yeah, it won't even load anymore.
People are all up in the shit, trying to figure shit out.
Temporarily unavailable.
Weird. Okay. Okay. All right. Downloads. Recent. Okay. All right. It's showing it as an image. All right. Okay. Okay. That was very difficult for me. All right. Let's see here.
Wait, is this the document or somebody on X?
Yeah. No, I want to pull it up. No, babe. Law Girls Not Attorneys sent me. It's a screen grab. It looks like of a portion of the docket, but also some additional information. Okay, so
all right, I'm gonna try a new tab here. This
Okay.
is ridiculous to me. That
You
this
work on that, and I'll make this thing bigger. Yeah, that's annoying that it's not putting it right on the stage. Why is it doing that? If that's something that StreamYard did, they need to get rid of it. All right, so here we go. So there's the action up there. You got 2484 CV 01447 Raymond C. Green Inc. as trustee of the Raymond C. Green Trust versus Fiorillo Nicholas et al. It's a tort case. File date 5/30 of 24. It's fast tracked. Status 5/30 of 24. Rachel Rollins is a defendant. Kevin Hayden is a defendant. Brian Albert is a defendant.
Could it be a different Brian Albert?
Peter Krupp is a defendant.
Who's Peter Krupp?
I don't know.
Oh, because somebody's like with Peter Krupp is
Probably
all people.
cops. It looks to be judges and cops, and a former prosecutor, Rachel Rollins. She was the one that remember from trial 4. She was running. And she won.
Let's just play the last minute of
And then here we've got it. And this is Mark Gildia, however you pronounce his name, the judge right there. He's an additional party. So he's an alias. So like, I don't know.
That's why I would like to get my hands on the actual document. But
yeah, wait, I think there's more. All right. So hold on.
It's
so
like
that's that. All right. But they included some other, it's like Whitey Bulger shit. It's pretty fascinating. I'm fascinated. Okay. Oh yeah. Let's see what it is. They had me at Whitey Bulger. Now I'm interested. Okay. Okay. Boop, boop.
All right, I'll be right back.
All right. Godspeed. All right. So this was some. All right. Hold on. I'm going to pull it up. Let's see what this is. All right. Let me pull that guy down. Boop. Okay. Hide this. Yeah, Allie's right. Like, usually when you share something on StreamYard, it typically, apparently I've got 2 studios running like a moron. I don't know what I'm doing. Okay, so remove that. Stop sharing that. Okay. All right. So this is the other thing they sent, which is interesting. All right, so this is same case number. Okay. Biggest cover up in US history by, all right, make it bigger. Okay. Biggest cover up in US history by Clinton, Obama, Biden, deep fake, deep state, $100 million catch, show trial, deep fake, death, prison break, whatever the fuck that means. Okay. Key identifying factors, comparison, probability calculation of 13 biometric features, FBI mugshot to cans. May 23rd is James Whitey Bulger, 1999. All right. Okay. Corporate. Okay. So this section provides an in-depth comparison of the FBI Bulger photos and Bulger cans May 2023 photos, incorporating precise measurements, texture analysis, and biometric descriptors.
Are you talking? Because I can't hear you.
Oh, I was muted that whole time. I'm sure the chat was telling me. Did you guys not even hear me read that shit?
No, if you read something, I'm sure no one heard it.
Wow.
Let's just see how long they've been saying you're muted.
Hours, 20 minutes, 12 minutes. No, 5 minutes.
Muted
yeah.
502. He's muted
The
502.
first mute. Now I'm reading. How am I supposed to see you guys?
No
screaming that I'm
sound, muted.
Wow.
Bueller, muted. Oh my God.
If you guys see me reading a document,
Get
on a
Allie
second
back in
screen,
here. Bob.
Where's Tracy? I'm sure came in and said I'm muted. Tracy, you have to come back screen and you've got to play this. You know what to do. We have a whole soundbite for it, for exactly that situation. Not this one.
Do something.
That one
Do
effective. But no, it's where is it? I can't even find it. Like,
I'll play it.
yeah, find it.
Go
All
read
right.
what you're
So
reading.
So the first thing that I was reading is apparently there's this somebody, and I'm assuming that this thing was
Bob,
filed
you're
along under
muted.
this that
Bob,
see, we
you're
have a whole
muted.
soundbite for it. All right, let's
That's
see.
me.
It is. Somebody clipped Allie telling
Well,
me muted.
it's the same Mark Gildea and the same Brian Albert, and we've got a huge fucking problem.
Well, but we need to figure out from the docket little entry what he is in the case. All it says is alias. So I don't know if he's a party.
I might have gotten, let's see, I might have gotten back in here. No. Oh, I'm in here. All right, hold on.
Okay.
Let's move slowly.
All right.
Okay, I'm not a robot. All right. You said Suffolk?
Yes.
Okay. Suffolk Civil.
Yeah.
All right. Did you have the full number? I can search by his name.
Yes, it's 2484 CV as in Victor 01447.
Oh my God, this page is not working.
Oh no. Oh no. What?
That's what it said after I did the search.
All right, hold on. I'm bringing this thing up again. So until Allie gets in there, this is all we've got. So this particular thing, which I'm assuming at some point Allie will. All right, so see, you've got this.
I'm just going to try by
where
his
it's
name.
showing party, Dougal alias, Peter Krupp is a party attorney, Michael Ruccotti, he's a party attorney,
Did I spell his
Helen,
name?
like so. Oh yeah, it says he's a defendant. There it is.
Gildea. Gildea. That's how you spell it, right? Mark.
Yeah, Gildea. Yeah.
And did you say the Suffolk Superior Court?
Yes, Superior Court.
Well, nothing's coming up.
Hmm.
Let me try. And when I tried the case number, it didn't let me. I'm going to try Brian Albert.
Well, you could put one of the defendants.
Okay.
So its last name is Fiorillo, Fiorillo.
Right. First
And
name.
first name Nicholas.
And
Nicholas.
OLAS. Yeah.
Yeah.
Nothing.
Nothing.
And you sure it's Superior Court, Suffolk County? Oh, wait. I'm in criminal.
Come on, girl. That's like me talking on mute for 6 minutes and not realizing it. I was reading the whole facial biometric shit. Essentially, what they were saying is that, like, Whitey Bulger's not dead. That he's like, there was this picture that popped up in 2023, and that it's 99.7%
got it.
Whitey Bulger. Oh, she got it. She did it. She did it. She did it.
Okay.
What a hero.
And nothing has happened since June of 2025. Motion to dismiss all counterclaims against them. Omnibus emergency courtesy motion to oppose plaintiff's extrajudicial.
Pull it up. Put it on the screen.
Oh, okay.
I'll pull this shit down. Whoop. Whoop.
Okay. So in 2025, this says defendant Nicholas Forioli's submission of, and look at the way this is named, omnibus emergency courtesy motion to oppose plaintiff's extrajudicial deepfake motion to dismiss counterclaims for lack of service with full reservation of rights. Jurisdiction remains in Southern District of Florida. Fort Pierce on appeal to the 11th Circuit stayed until August of 2025 under civil rights protection. Okay, blah, 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 blah. I don't know what all that is. Motion to dismiss all counterclaims were allowed. So maybe he might have never even been served.
Tracy texted me muted at 5:01. Here's the problem. I turned my phone volume off, so I have no idea. No idea. I am like in a cocoon of ignorance when I'm on a live stream. I just don't like, I'm not in with the real world. So, I mean,
filed.
So Law Girls said they sent us the entire complaint.
Oh, well, now we're.
Oh, yeah.
I mean, his name's only in here as the party. So.
Okay, this is the civil complaint.
It's up on the screen for everybody.
Oh.
So.
Okay.
GIL. His name's not in here.
What? It's got to be somewhere.
Well, let me make sure, like, I'll put a word that I see because it might not. Yeah, no, it's just not working. Okay. Ocean Trust, Plaintiff, Trust Massachusetts Organization, Defendant, Defendant Group. Wow. Why are they all the same name?
Wait, do you have the complaint?
Are you not looking? Is it not up? Share my screen.
Yes, ma'am. Yes, ma'am. This? Wait, no, that was up, but it's not the. Oh, there you go.
Yeah. Jesus.
Something crazy is going on.
Yeah. I mean, so far, talking about a note and a loan, commercial paper.
What does it have to do with Whitey Bulger? I'm very confused.
I got to download it. I'm going to download it.
It's a nothing burger. He's like Fiorelli sues everyone. It's like a JRR or JLR type character. Just files lawsuits.
Okay, so Albert, the name Albert's not in the original complaint. And neither is the word.
All right. Yeah. Let's see. I'm going to start. Where did you leave off on the supers? I got to eat. Have you eaten today? Like something?
No.
Anything? It's 5.
No. I know.
This is outrageous.
So whatever it is, I mean, it might not even be that they were like knew that this exists.
Okay, so I think Edward had sent. Did you read this one? Judge better keep the same energy for Tully's motion that contains an explicit
they're
lie.
light. Don't forget they're light.
Oh yeah. Okay. Oh yeah. Forgot that. I don't remember reading some of these
because you weren't listening.
Oh, that's probably true. Okay.
I mean, all this says is doesn't even say when he was served.
You read D Nice with all the smiley laughing faces?
Not 100% sure.
Come on, girl. We appreciate his classic overthinkers sent the exact time in the video when they were all screaming at us. Don't be morons. We're telling you the answers. Edward sent another $5. Said there needs to be an evidentiary hearing on this now. Strategically, also.
Yes, I read that. Okay. Yes. Okay, got it. It was this counterclaim by defendants, aka NE Edge racketeers. This is some kind of crazy shit. I don't know. All
right, so Lena Loves Trials.
They sued
Oh my God. Can you guys hear me? Can you hear me? I am on like 3 bars from my phone. So internet outage and our Starlink isn't working. So it's probably the heat. It's like as hot as the sun here. So all right. Well, thanks for you guys that hung through that horrific delay. I'm gonna end it, but I can't even tell. Why am I so teeny? Let me see if there's some way I can change it. I'm not used, like, I do not know how to use this from my phone at all. Wait, it should be working? Oh, you did? Oh, all right. Hold on. Wait, Ali says I can get on StreamYard. I know there's like 1,100 people left. All right, let's see here. Okay. Oh, I don't know. She said she can get on. I can't get on. Let's go. Let's see. Yeah. I think she gave me bad intel. All right. Well, I'm super teeny, right? I don't even know how to change it on here. I think you need to come back stage trace and like figure out how the hell to change me. Like I just don't know. Let's see. Wait, maybe here. Yeah, Trace, I can't even find like the different set. Oh wait. No. No, it's comments. I have no idea. Oh, there, that's better. I did something. Yeah, I cannot get on through the internet yet. So I don't even know how to pull up supers. Let me see. Oh, wait, here we go. Wow, this is super small. This is horrible. It's horrible and clunky. Can't thing. Let's see, Tracy. I made you big. Oh, thank. I thought it was me. Ah, wow. Okay. All right. Good times. Good times. Yeah, this is going to be. Oh, he's gone now. Can you guys hear me? I don't even know what. I don't know where the camera went. I think my signal's too shitty to have like the video working. I don't know. I just don't know. Wait, Ali entered.
Everybody
Oh,
waited?
wait, what are you on? Are you on Starlink or
Yeah.
the regular internet?
No, I'm on Starlink.
All right, let me see if that works.
But you got your sound all jacked. It's echoing.
It's because I'm on some weird little mic. I
Oh,
can't
yeah,
get
yeah.
on. All right, you're gonna read the supers and like I'm
All right.
not. All right. I'm not
Okay,
getting started.
goodbye. Jeez. All right, let's figure out where we were because they do that thing where they stop highlighting it or they shade it or whatever. Okay. All right. So I think it's Lena loves trials. Allie girl, love you so much, but maybe it's time for the second monitor. I mean, it's all the way over there. Thank you for your generosity. Larry is currently in Paris. Maybe that's it. But it sounds like, I mean, maybe if I don't know. It's possible. It's very confusing, this time change thing. But thank you for your generosity. Jenny Marie says, didn't Axel Jones get a default judgment against him for the same thing? Isn't Mate on this case? I don't know. Oh, the lawyer. Yeah. Okay. And I don't know the answer to that, but maybe people in chat all responded to you and do know the answer to that. Sue Mo 78 says, I would just like this judge to know I am watching from England and I am not happy. My phone starts ringing. Everything falls off. My God, I'm falling apart over here, people. No, not happy. Not happy. He needs to right his wrong. Mish from North Ireland, thanks for your continued support on Catch Up. Family hugs. Aw, family hugs. Thanks for your continued support. For the virtual juror, thank you. Gildea was pretty similar today. I listened to the case right before Karen, but it wasn't prepared. It was argument. He had a similar demeanor with them. Sounds like that case and and it sounds like that case with Gilda and Brian Albert might be crazy pro se person. It might be. I couldn't figure it all out like while we're on a live. So Mish from North Ireland gifted a membership. Thank you. Very generous of you. Just a Girl from the Stick says it's a 2025 civil suit. Text Mel, she did text me back. Bob, you don't like Rush? Shaking my head. I met Neil Pearl years ago in Toronto. He was such a nice man. Yeah, I don't know, Bob. He's got like a thing against Rush, I think. But thank you. Tracy Thompson says, let Alan Jackson know judge is a co-defendant with Brian Albert in civil suit. And she gives the number. I mean, I'm sure by now he'll know. I can't even tell if they were actually served to even know that they were ever named defendants in that action because there were a bunch of counter defendants. I don't know because those counter maybe third party defendants. I got to figure it out, but it's something weird. At for Dread says someone said could be a sovereign citizen filed frivolous lawsuit. Yeah, it's something wild. I mean, like you guys saw, we just don't have time to keep reading it today. I actually still have the damn, docket up. Oh yeah, Brian Albert. Yeah. Let me just see who signed this thing. Yeah, Nicholas. Yeah, pro se trustee. Yep, he is. And this again was it looks like defendants answer affirmative defenses and counterclaims and cross claims. So, and that's why I was confused. It can't be a counterclaim because you can't counter someone who's like not in there. So he filed against all these other people, like a whole ton of them. But then the court ultimately dismissed it. because there was no service, which could mean that they never actually even served. Like the judge might not know. We might not even know. So that it might be grounds, it might not be. I mean, it's something. It's the appearance of impropriety. I don't know. Um, yeah, they just dismissed it. The plaintiff served his motion to dismiss, but it received no opposition. Then this guy Fiorilos or whatever, Fiorilos, I don't know. The court read it and he said he gave it careful consideration. And after all that careful consideration, it's dismissed because the counts contained in the counterclaim have been previously asserted and voluntarily dismissed in other actions by the defendants against the plaintiff on at least 2 and sometimes more occasions. There are 9 counterclaims. The court notes that these claims have previously been asserted, and he lists all the courts where he has asserted it before. Accordingly, I enter an order allowing the motion to dismiss and dismissing the counterclaims with prejudice. So it sounds like they ended up, going nowhere. But we can still look into it more. I mean, it's things like this guy filed things that say omnibus state court notice of extrajudicial orders attempting to dismiss appellant's rights, a 90-day automatic stay, blocking anything, snap remand orders, attempting to remand the inextricably related cases back to the First Court of Massachusetts, exposing Clerk Smith's attempt to catch and kill appellant's civil rights and due process between. I mean, this is what this guy's filing, so everything was denied and it's been dead for a year. So moving on. But he's definitely pro se, so there's that. I don't know. Oh, I'm back. I have no idea for how long I was gone. Or if you could hear me during that period that I couldn't see my. All right. I don't know how much longer we're going to be able to do this. Case numbers in chat. We are talking to y'all. Yeah, we get it. Thank you. Thank you. DRP. He comes back. Catch up on the chat. We're totally telling you everything. Yep. We know. You guys are amazing. Mathis Grays. So kind of like Macy Gray, but Mathis Grays. Maybe. I don't know. Yep. As trustee of a trust, you only need to read the plaintiff to know this is a BS lawsuit. Now you know why there's no conflict. Yes. Agreed. Thank you. Yes.